we're ready.
Okay.
Your Honor, if I can
Hello,
say something,
hello.
while we've been waiting to be called, my office was able to locate an amended notice of hearing, so I would withdraw the objection that I made in the opening. I still have reservations about whether or not we can finish everything in 3 hours, but I no longer have an objection to lack of notice.
Understood. And let's just review that. It looks like my notes on the docket indicate that we have a motion to compel, a motion to bifurcate, and then a request for interim attorney's fees. Is that your understanding of what is at least set for today?
Yes, and while we've been on a break, Respondents Council informed me that they agree with my motion to bifurcate the proceedings. So I'm going to circulate a proposed order, and hopefully we'll have that to you later today.
Okay.
That's true, Judge.
Great. Thank you, Mr. Laverato. So Ms. Seeger can get it to me. So that takes us to 2 issues for today. All right. And are we ready then to proceed with openings?
Yes, Your Honor.
Okay. And let's see. I guess both of the remaining motions are the respondents. Am I correct on that?
That's correct.
Okay. So then you may proceed, Mr. Laverato.
Thank you, Judge. May it please the court. Your Honor, as a matter of some background here, first of all, I know that Mr. Burnett submitted a legal memorandum in opposition to our motion for interim fees. That goes over some of the background of this case, just factually. But so the court understands, this particular case involves the 2 parties here before you who've been married twice. Okay, they were married once in December of 2021, and then they were divorced and then married again in December of 2022. Okay, prior to their marriage, they have several children. My client has 3. 2 of them are minors.
God.
Mr. Zeipman has 8 children with other biological
Married
parents.
not once, but twice.
There's a prenuptial agreement that existed
to the same
in both
woman.
the first and the second marriage. We have alleged and claim in this particular case that prenuptial agreement specifically related to the second marriage is unenforceable, and we've cited that in the First Amendment answer and
that's the dumbest thing I've ever heard.
That is going to be decided on a later date. We've just bifurcated, and that will be that issue. During the marriage, Your Honor, both marriages, the parties lived together most of the time in what's known as the compound here in South Austin. Okay, actually commonly referred to as the clown house because there's these 2 big pictures of clowns on the side of a barn near an elementary school. Anyways, they lived on this particular
and because they're clowns for getting married twice.
When they were not together, all of the items that we're going to talk about today stayed at the compound or another building known as Medical Parkway, controlled by Mr. Zeipman and only Mr. Zeipman. The estate, let me just call it that way. The estate is likely worth hundreds of millions of dollars in this particular case. Again, the issue of enforceability of the prenup's not what's before you. We're not asking you to divide any community property or property belonging to the alleged community. At the core of this motion, Judge, really, it's about establishing fairness and equal footing. Because on the one hand, Mr. Zeipman has essentially unlimited funds to pay for his attorney and essentially defend that this particular prenuptial agreement is enforceable. On the other hand, my client has virtually no resources to do that. It's been no spousal support or no other source that Mr. Zeipman has provided to my client. And so basically, she's on her own having to prosecute and make these claims regarding the enforceability of a prenuptial agreement without any resources, to the extent that she owes our firm at this point over $140,000. She's paid $70,000 plus. Okay, with regard to the personal property we want returned, I have to show you 4 things, Your Honor. Number one, I have to show you that the property was owned by my client and was her separate property in some way, whether that be by gift, inheritance, but that she owned it. And the evidence in this case is going to show that she did have possession, she did own these items, and that she was either given these items or owned them prior to marriage. Number two, I have to show you that she possessed those things at some point in time, and the evidence must show that she did. And there will be my client testifying to that, and also her daughter, Vivian, who's here as well. Number three, I have to show you that she lost possession of them at some point. And in this case, the evidence will show that they, more likely than not, ended up with Mr. Zeifman. They didn't disappear. They remained at the last location they were seen, which is either going to be at the compound or Medical Parkway, where now Audrey, my client, has absolutely no access to. And Mr. Zeifman has full control over those premises. And then finally, number four, she no longer has access to get back to them for all the reasons I just stated. She does not. I don't think that there is going to be any dispute that Mr. Zeifman has exclusive possession and control of these pieces of property that I'm talking to you about. And I don't think that there's going to be much dispute that he was the one that really safeguarded the items that we're going to be talking about at some point with regard to putting them in safes or securing them at the locations that he has control over. If you believe, Judge, more likely than not, that she owned these items, that she possessed them, and then at some point Mr. Zeifman had control over them, then we ask that you order him to provide those back to my client. And if he says that he cannot because he doesn't know where they're at or that they didn't exist or something like that, that he should pay for them. With regard to the attorney fee request, again, at the core of this motion, it's really about fairness and my client's ability to be able to participate meaningfully in this litigation. The personal property that she wants you to order Mr. Zeifman to give back, she didn't want to wear that stuff around town. The only thing she wants that stuff for is to be able to feed herself, feed her kids, and to be able to participate meaningfully in this particular litigation. And the court has broad discretion under Family Code Section 6.502 to order interim fees, and we ask that you exercise that discretion. The brief that was submitted this morning in opposition to that, I just got, they cite the Eaton case, which is a Fort Worth case, 2014. It's Westlaw 4771608. I don't think applies in this case. First of all, the Eaton didn't have to do with the premarital agreement. It had to do with the postmarital agreement. And it had to do with already dividing the properties of the parties, but whether that be community or separate. There was already a determination. The parties had agreed what's separate and what's not. And so the court, in that particular case, since that issue had been determined, it was found that the court abused discretion when it ordered interim fees. Here, that hasn't happened yet. Whether or not there is a community property to divide is to be decided later. And so on the one hand, they want their cake and they want to eat it too. I mean, they say that, well, that everything belongs to Mr. Zeifman and that she signed away any rights to that stuff. But on the other hand, they want to say, but even though she doesn't have the money to participate meaningfully in this case, Judge, you shouldn't order interim attorney fees. And there is no case, and believe me, I looked hard, that would stand for that proposition. You, Judge, have the full discretion and broad discretion under 6.502 to level the playing field, or at least make the playing field a little bit more level. And that's what we're asking you to do, Judge. That's all I have. Thank you very much. I appreciate your time this morning.
All right, Mr. Burnett.
Yes, Your Honor. As counsel said, this is the second time these parties have been married. What we're here for right now is a divorce on a short-term marriage. involving no children. And by way of background, in December of 2021, the parties executed a premarital agreement. And attached to that premarital agreement was detailed financial disclosures that Mr. Zeifman made to Miss Zeifman at the time. About 5 months later, in cause number D1FM 22-003807, Mr. Zeifman filed for divorce. And I requested the court take judicial notice of that file. And
I will do so.
Okay. And then before I forget, I do want to invoke the rule. They've designated Ms. Zeifman's minor daughter as a witness today. I don't think it's appropriate. We can take that up if they do indeed call her, but I want to make sure she's not present on the Zoom call.
Okay.
I'll confirm that she's not, Your Honor. And she's standing by, and when she's ready to go, we'll have her click in.
Okay. All right. The rule has been invoked. So, counsel, you're both reminded that you need to instruct your witnesses accordingly. And if any witnesses are watching on Zoom, you need to stop viewing the proceedings on our live stream. And just one other thing before we proceed any further, Mr. Zeifman, the rocking back and forth, or the movement is really, I have pretty extreme motion sickness. And so if you're not able to sit still, that's fine. I would just ask that you perhaps turn off your video until you're called. I'm getting a little sick here because of this.
I apologize.
That's okay. It's just with something about being on Zoom, ceiling fans I can't tolerate, and other things like that. So you are welcome to, if it's easier, if you want to turn your video off, you may do so. You have my permission.
I appreciate it. You're not the only one who's complained.
Okay. All right. No
Thank
worries. It's just, it will be easier for me to concentrate on the evidence if I'm not nauseous. So, all right. Go ahead, Mr. Burnett.
God, society.
Going back to the original divorce
Are
case
we this
between these
week?
parties in 2022. As I mentioned,
All
they
of
had
you.
a prenup that they
Every last
executed
one
before
of
they
you
got
was a
married
week
in December of 2021.
with
that,
a Marine
had,
drill instructor.
Financial
Every last one of
disclosures,
you.
a waiver of further financial disclosures in the prenup. I'll refer to that as the first prenup in this hearing. And then the first prenup provided that there would be no community estate, and each party waived any claims or demands against the other person's separate estate that had accrued in the past or would accrue thereafter. When Mr. Zeifman filed for divorce in May of 2022, Ms. Zeifman hired Daryl Wyman to represent her in that case. And Daryl Wyman, on behalf of Ms. Zeifman, filed a challenge, a counter petition that's in the record, rather in the court's file that you've taken judicial notice of challenging the first prenup. And she alleged that it was unconscionable, executed under duress. She also, in that case, filed an EEOC complaint against Mr. Zeifman. Mr. Zeifman had provided support to her through one of his companies. She didn't have to do any work for it or anything like that at all. But she received a paycheck and health insurance benefits through one of his companies. During that first divorce proceeding, Ms. Zeifman then filed a demand for money damages from Mr. Zeifman, claiming employment discrimination, and claiming even though she didn't do any work, that she was subject to 13 hours a day of work.
Judge, I'm going to object. I mean, this is stuff that I'm pretty sure we're not going to hear this in evidence, so I don't know what this is, and I wouldn't call it an opening.
Not
but
getting
to me, this
married
is
in the first
inappropriate. I
place.
thought we were going to litigate the issue of the enforceability
fantastic.
today.
Your Honor, and I'm not going to go on long about this, but it goes to the credibility of Ms. Zeifman, which is right at point and at issue when we're dealing with these property claims that she's making in this case.
All right. I'll overrule, but let's try to keep it short.
All right. So she alleged sexual harassment in the workforce, all that kind of stuff, whatever. Ultimately, she got into a dispute with her first lawyer. She dropped the challenge to the first prenup. And on November the 7th, 2022, the court granted an agreed final decree of
I
divorce in
heard
the
what a
case,
complete idiot.
confirming that there was no community estate and each party was awarded their separate property. Shortly thereafter, Mr. Zeitman was notified that Ms. Zeitman was involved in an automobile accident. I think she was driving an e-bike. There's some dispute who was at fault for that accident, but she suffered some injuries. Mr. Zeitman went to see her in the hospital. They started talking again and repaired their damaged relationship. And so about 6 weeks later, on December the 21st, 2022, the parties did two things on that day. First thing they did that morning is they executed what I'll refer to as the second prenup. That's the prenup that's involved in the present case. It is the exact same prenup that she executed a year earlier. The only difference, it doesn't have the financial disclosures attached to it, but everything else in that prenup is verbatim, word for word. And she already had the disclosures from Mr. Zeitman from the first prenup that again was executed just 12 months before the second prenup was executed, and confirmed by the court in the final decree of divorce 6 weeks before she executed the second prenup. So they got married on December the 21st with the same prenup as they had the first time around. History repeats itself. 5 months later, in May of 2023, Mr. Zeitman decided to file for divorce again. Now, this is important to keep in mind. Since they got married the second time in December of 2022, the parties never cohabitated together. She never lived with Mr. Zeitman on his property here in Austin. At all times, she had a separate residence. Of course, she would go over and stay at his place at sometimes, but she had a separate residence at various locations in Austin, Texas, that Mr. Zeitman rented on her behalf. One was at the Grove, there was another one in Clarksville, there was one off 2222, there was one in Northwest Hills. She always had a separate residence where she resided with her daughter, Vivian, who's on their witness list.
Straight hooker.
In May, May of 2025, 2 years after he filed for his divorce, he decided to non-sue the case. And they went on a vacation that summer that did not go very well. When he returned the fall in September of 2025, Mr. Zeitman filed his third petition for divorce, which is the one we're on before Your Honor today. And he notified Ms. Zeitman that he was done this time. He could no longer do it. We don't have to get into it, but he just couldn't handle all the drama that was going on. She then went and hired counsel that's here before you today. And just like the first time, back in 2022, they allege that the second prenup is unconscionable and signed under duress. Same defense as the first time. I guess the claim is that he tricked her twice. I don't understand it. And in this case, they've alleged that perhaps she wasn't competent to sign the second prenup.
Fair enough. Perhaps I spoke too soon.
On December the 21st,
I don't know for sure.
2022.
That was just a guess on my part.
And if that's the case, and we'll find out during the trial, as an aside, I don't know how you can be incompetent to sign a prenup, but then competent to get married. We'll deal with that before the trial judge later. But they filed that complaint at that time, that allegation at that time. That was in October of 2025 is when their answer and counter petition came forward. In November of 2025, Respondents Counsel contacted me and said that she needed to get clothing from Mr. Zeitman's properties for her and her children, her child, Vivian. And we made arrangements last November to have that property delivered to Miss Wynn's office. And that all happened. I thought everything was fine. We're going forward, doing the discovery in the case. We arranged for depositions either in February or March of this year. And in February, the date, the month that Mr. Zeitman was notified, I received notice from Respondents Counsel claiming that Mr. Zeifman is in possession of very valuable jewelry that Ms. Zeifman claims to own that is in excess of over $200,000. That was the first time we received any notice that we were so-called in possession of this valuable jewelry. When they tried to get the close in November of 2025, there was no mention of this valuable jewelry. I mean, one of the pieces of the jewelry that they're claiming we're in possession of is supposedly worth over $100,000. Now, I think it's going to be an issue of the credibility for them as to why they would ask for a close in November of 2021, but nothing about this very valuable jewelry. I've responded to them on multiple occasions, telling them two things. One, we don't have possession of the jewelry you're claiming. Two, we have possession of some of her clothing and personal belongings that were located at a property in Sweetwater, Texas, and a property in Midland, Texas. We don't know what's in those boxes because we had someone else box up her belongings on those two properties owned by Mr. Zeifman. And I've told them on multiple occasions, let me know when you want to go pick those boxes up. We've also notified them that we have a piece of yellow furniture that they've inspected, and they can take it anytime they want. Thank you. And further, we have possession of an e-bike that belongs to her that they can have at any time. But all these other belongings, all this valuable possession, this jewelry, a Tiffany ring, supposedly worth over $100,000, some other ring. I mean, you look at the list, it's like astounding that she wouldn't have asked for it earlier than 6 months or 5 months after the divorce petition was filed.
Seriously, this guy's a billionaire and he's getting run around by this? You've got to be shitting me. That doesn't even make sense. I'm sure she's younger, but come on. She's a slow Tuesday at best.
We don't have. And their request for relief is really premature at this time, Your Honor. That is a final order request for relief. That's an order. What they want you to do on temporary orders is to give her property that we say we don't have. And since we say we don't have it, give them money damages for this so-called lost property. You can't do that on temporary orders. That's a final order. If we've somehow stolen her property, then she needs to sue him for conversion and seek money damages. And then you have an actual trial of whether or not and a fact finder decide whether or not he has possession of the property. And if so, what's the...
I get you're joking, but there is the most ridiculous theory of the day.
value of that property. And we've demanded a jury trial in this case. If she wants to claim that we've stolen her property, then that's the subject of a final trial before a jury who will decide who's telling the truth between these two people. That is, who has actual possession of this property. And if Mr. Zeifman does and fails to give it to her, then what are her damages? You can't do that on temporary orders.
Oops.
The second motion that they have deals with the interim attorney's fees.
I was muted for she was something before electricity line, ripped off straight from Rodney Dangerfield.
The purpose of a premarital agreement is so you don't get into these fights, okay? And this premarital agreement says that you waive and release any claims, demands, or anything you want against the other person's separate estate. And under the case law, it's clear that this premarital agreement is presumptively valid and enforceable until a court determines that it's not. Right? And what they're trying to do under this premarital agreement is have Mr. Zeifman's separate estate, because as we sit here right now, there's no community estate for either party. They want his separate estate to pay her attorney's fees. And the Eaton case says you can't do that. The Eaton case is the only case out there dealing with the award of interim attorney's fees on temporary order.
Coochie. Gotcha.
Now, Mr. Lavarado said, well, this case is different because it involves a prenup and the Eaton case involved a postnup. There's no distinction under the law. If you look in the family code, you can do a prenup and make it all separate property. You can do a postnup and make it all separate property. It makes no difference whether or not it's a prenup or postnup. And the Eaton case specifically held, in that case, the trial court ordered the husband to pay interim attorney's fees from his separate estate under the marital property agreement, and the Court of Appeals granted the mandamus and overruled the trial court. The Court of Appeals held in the Eaton case, you cannot do that. You cannot divest that person's separate property to pay the wife's attorney's fees when in that marital property agreement, the wife had waived and released any claims against the separate estate of the husband. And that's exactly what we have in this case. In the second prenup that you're going to have in evidence, just like in the first prenup, Ms. Zeifman specifically agreed, no community estate, it will only be separate property of each of the parties, and there's a waiver and complete release of any claims, demands against the other party's separate estate that had accrued in the past or were thereafter accrued in the future. And so the Eaton case is right on point. Now, what counsel can do is, if he can go to trial and set aside the prenup, then you do have a community estate. And at that juncture, it might be appropriate for them to request interim attorney's fees, but not beforehand. Now, lastly, counsel said and tries to paint this picture that Ms. Zeifman doesn't have any money, is destitute, can't afford this fight. Okay, two things I want to say on that. Number one, she testified in her deposition recently that she just got a new job making 6 figures. That's number one. Number two, she testified that she has approximately $60,000, I think it was a little shy than $60,000 in her bank account. 3, Mr. Zeifman continues to provide her a salary so that she and her children, who are not his kids, by the way, can have health insurance, and he also pays for her cell phone. Fourth, and lastly, Your Honor, any fees that they do get, which are not proper under the Eaton case, but even if they were, they have to be reasonable. You have to have reasonable fees. Here, respondent's counsel has billed her almost $250,000 in legal fees so far. And my testimony is going to be, when we get to this, that is not reasonable. I've not kept detailed bills of what I billed Mr. Zeifman. I've not sent him a bill yet, but in preparation for this hearing, I've gone through and looked at what I've done and what my office has done. And my fees, when I send him a bill so far, will be approximately $30,000. $30,000 to $250,000. All we've done so far, Your Honor, is we've deposed the parties, exchanged written discovery. We haven't had any hearings before today. And so even if they can get fees, which they can't, that doesn't mean you can just get whatever you want. If counsel's owed $130,000 or $140,000, they still have to demonstrate that those are reasonable fees. And I think $250,000 in fees is unreasonable for 2 depositions, the exchange of written discovery in the case, and no court hearings. That's all I have.
Okay. Mr. Lavarado, you may call your first witness.
Yes, ma'am. Thank you. Can you hear me okay?
I can, but keep the volume up.
My first witness is Audrey Zeifman.
Okay. Ms. Zeifman, if you'll raise your right hand and be sworn, do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
Ma'am, are you a whore?
Your full name for the record, please.
Audrey Zeifman.
And you filed this motion today, correct?
Yes.
And you're currently married to Mr. Clifford Zeifman.
Yes.
All right. And you heard some of the opening statements here and the timelines, you've been married to him twice now, is that right?
Yes.
And the second marriage, when were you married to him, please?
The second marriage, I was married on December 22nd, 2022.
Okay. And wasn't that the day that you signed the prenuptial agreement that is in connection with the second marriage?
Yes.
Okay. Had you seen that prenuptial agreement prior to signing it on that day?
No.
How soon before you were married did you sign that agreement on that day?
I believe
In
I
other words,
signed
was
it.
it a matter of hours, minutes, days? What was it?
One at a time.
It was in the courtroom. I mean, it was in the office of the notary.
Okay. In connection with that particular agreement, was there anything attached to it that showed you what the estate was that Mr. Zeifman said that he had? Or was it just the agreement itself?
No, it was just the agreement itself. I didn't remember.
Got it. And let me ask you this, are you employed now?
I'm not. I don't have a job. I did have a job, but I don't now. I am.
You recall that Mr. Burnett took your deposition about a month and a half ago? Is that right?
Yes.
At that time, was it your understanding that you were employed?
Yes, I had a contract executed and a
And what happened?
supervisor.
What happened after that?
The day
Oh my God,
after the
she is insufferable. Absolutely insufferable. I get it. Maybe a few years ago, she made up for it, but not now. Holy shit. She's slow. She can't think. This is your examination. You're prepared for it. On top of being lame. She's got an eat, pray, love sign in her dining room. I'm telling you right now.
deposition where I had stated that I really didn't want to reveal the name of my employer or supervisor because of past patterns of Mr. Zeifman in interfering with work. I did so anyway, and the next day, my company, everything just went away. All of a sudden, my supervisor was no longer my supervisor.
Yeah, that would help.
They stopped communicating with me.
It's not what we're dealing with here.
It's just gone.
So you don't have an income at this point from an employer, correct?
Correct. I don't have an income from an employer, although I am doing what I can. I'm cleaning houses. I'm renting my car.
In her defense, her burrito selling days are behind her. She was trying to sell this one big burrito, but she screwed it up.
And I'm starting to teach a couple of yoga classes. And my daughter is working. She's working full time right now.
Okay. Ms. Zeifman, during your marriage, and let's talk about the second marriage, where did you reside?
In the second marriage, I primarily resided at the compound.
I call absolute bullshit. She is not cleaning any houses. She didn't go from married to a billionaire to cleaning houses. That is an absolute sham that they made up for direct examination to make her look sympathetic and relatable. It's a bold-faced lie. I do not believe it. Of course, I don't know. I'm just telling you what I think.
What is that? Just kind of describe what the compound is for Judge Mangrum.
It's a 20,000 square foot property with separate buildings, and I believe there was 5 properties 5 lots purchased but that were all combined. It's a big metal fence, and the first thing that you see in the front entryway is a giant red garage, bottomless garage, top's the gym with really giant clown faces. And the entryway, you enter the kitchen, and that's where it's a 2,000 square foot commercial kitchen.
That's okay. Let
And
me keep going. Because I got to get, so other than that particular residence, did you reside any other places? Like, for example, did you have other places that you could sleep at night?
I did sometimes. So yes, at
Okay.
times I did.
As did Mr. Zeifman, right? I mean, he had other pieces of real property that he owned that he'd go and stay overnight as well, correct?
Yes.
Okay. During your marriage, did you keep personal belongings such as jewelry and the things that we're going to be talking about today at the compound?
Yes.
Okay. Did
I
that
can specify.
did that type of
Sorry, I didn't
property
hear.
include jewelry?
Yes.
Did it include gold coins?
Yes.
Did it include personal documents like passports?
Yes.
Prior to your separation with Mr. Zeifman, did you always have access to those items, or was it something that he controlled where those items were on the compound or elsewhere?
He had sole control of where my items were located.
When you say items, the ones that we just spoke about, right?
Yes.
Jewelry, the gold
Yes.
coins, passports, right?
Right.
Why is it that he was the one that had control and custody of those things as opposed to you?
Well, in March of 2025, he had demanded that I bring all of anything that was worth anything valuable from the safe house apartment where I stayed sometimes to him to put in his office in a safe at Medical Parkway, because we would be traveling all summer, and Linnell that property was not a safe place to keep anything valuable. As for the other, so that was the first time he was in possession of everything, all of my heirlooms.
And we're going to go through the individual items, Ms. Zeifman. What I'm really wanting to know is, why was it that it was he that would have control over these items? Did he tell you that that's the way that he wanted it, or just kind of describe briefly how that came to be?
He insisted. He said, it's stupid to keep your stuff at Bunnell all summer. It's not as safe of a neighborhood. It backs up to 2222. It's easy that we don't have the security there, and it's more likely to get broken into. I have full-time security, and it's dumb. You need to bring it here.
Okay. I'm going to go through some items of property with you now, okay? And then we'll talk about specific pieces. I'm going to share my screen, Your Honor, if I may.
You may.
I'm looking for the AirPlay piece on my share screen to use TrialPad, but I don't see it. So I may have to have my paralegal go through this. Go ahead, Ms. Martinez, if you would put up R1. And these are all in the box, Your Honor. Ms. Zeifman, what is this that we are looking at?
That's my wedding ring that Mr. Zeifman gave to me in December of 2021, just
Okay.
prior to, and that I wore and had in my possession until through the second marriage in
Is
2022.
this an accurate depiction of what that particular ring looked like?
It is.
Okay. Your Honor, I'm going to request to move this into evidence, this exhibit R1.
No objection.
It's admitted.
Okay. And Ms. Zeifman, did you wear this ring regularly?
Yes, I wore it. I wore it every day.
Okay. Is this particular ring a ring that you have in your possession now?
No,
Can you describe it? In other words, how many carats was it? Is that a diamond? Just briefly.
it's a real diamond, and it told me it was over 3 carats. Asher cut. It has platinum band.
Okay. Go to the next page of this particular exhibit. Again, this is all in the box. Is this ring here that you're wearing the same ring that we were just looking at?
Yes,
Okay. And then this is a picture of you and Mr. Zeifman at dinner, right?
yes. Well, it may be lunch.
Okay.
Yes.
All right, go to the next one. And is this the ring on your finger as well that looks like you're taking a picture of yourself in a mirror?
Yes.
Okay.
Alright.
When was the last time you remember seeing this ring?
Was in
Oh, I cannot stand this basic bitch. I just cannot take it. I can't. This whole thing.
early 2023.
Do you know
when
where it went or who took it?
I believe so. Yes,
Okay.
I know who
Tell the
took it.
court.
I was been in Portland, and where Clifford had said we were going to pick up my ring. And I said I didn't want another ring, but so I was wearing that one. And he told me that that this was my ring, but he had too many he's too emotional about it, negative memories. So he was putting it into a safe at Medical Parkway and I could wear it later whenever I wanted, whenever he was healed. And so he took that from my finger and put it in a box. I don't know if he put it, I think he put it in the box that the next one came from. And he gave me the second ring on that day.
Okay, so we'll call this ring that we're talking about right now, ring 1. Was that the last time you saw it?
Yes.
Okay. Miss Martinez, please bring up R2. And if you turn to page 11. First of all, Judge, this is these are sworn up documents provided to counsel and discovery, date stamped on the bottom right. I'm just going to turn to the relevant portion of the document and ask my client some questions. Right there. What is this document that we're looking at?
I can't see very well. Okay, hold on. This is an record of the purchase of the gifts of jewelry, that my ring and earrings that Clifford.
I specifically want to focus your attention to the top portion of the page that we're on, and there's a number that says 861-28310. Do you see that?
Yes.
Okay.
Oh, excuse me, what's the Bates number on this page? Okay.
Okay. You see the description, Asher 5-carat diamond GIA ...
Yes.
Okay, is this a description of ring one that we've been talking about?
I believe it's the other one.
Which one?
I didn't have it appraised, but he had told me it was, well, he told me it was over 3 carats. So I don't know which one it was. It was the same.
Okay. Okay, you can take this down then. You indicated earlier that there was another ring that Mr. Zeifman purchased because the first ring had bad memories or words to that effect. So did Mr. Zeifman purchase another ring for you? Did you answer?
I didn't hear
You're
that.
cutting out a little bit. Go ahead and answer again, please.
Well, yes.
Okay. And I'm going to put up on the screen an exhibit here that is a description of another ring. Why don't you bring up R4? Okay, stop right there. Ms. Zeifman, do you recognize this particular document?
Yes,
Okay,
it was in my possession.
what is it? Does it describe ring 2?
Yes.
Okay, and see where it says shape and cutting style?
Excuse me, Your Honor, I object to the counsel asking the witness any questions about this exhibit until it's admitted into evidence.
That's fine. Is this a document that you've seen before that you can verify is true and correct?
Yes.
Okay, move to admit it into evidence, Your Honor. It's also been provided in discovery.
I object hearsay.
All right. What's the response?
Well, it goes to her state of mind in terms of what this particular ring looked like in her memory.
State of mind is when the witness says something about what their state of mind is. It's not a basis to overrule a hearsay objection to an appraisal report that's not certified and does not have a business records affidavit.
I'll sustain.
Okay, you can take that down, Ms. Martinez. You recall that the ring number 2 was a diamond ring.
Yes.
How many carats was it?
Same 3, a little over 3.
When was the last time you remember seeing that ring?
I remember seeing it last in May of 2023.
Okay, tell us the circumstances of that. In other words, did Mr. Zeifman take possession of it or what happened?
He did. He took possession of it it said he was going to clean it, get it cleaned. And so that took some time. And then
Yeah, I'm gonna clean it. It's like the Grinch when he stole the Christmas tree. He's gonna take it home and fix it. Meanwhile, the guy doesn't give a shit about the ring. He's got billions. He doesn't care. He's finally gotten to the point where he hates her. I don't know how he didn't get there sooner.
we left. He filed for divorce unexpectedly, and we were supposed to leave town, and I didn't see him again. So he kept that.
Where were you when he took that ring?
I was at where all of them was in his kitchen at Churchill.
At the compound?
Yes.
Okay. Have you seen it since?
She is absolutely insufferable. I don't know, like maybe back in the day, okay, maybe 15 years ago she was hot or something, but there's now she's just annoying and slow and stupid. I don't see how he can do it. Look, I mean, I do this all the time, but it's like, yeah, he's a billionaire. Most people aren't billionaires. Any man, if you have any money or think you will make any money in the future, you cannot get married. Period. End of statement. That's it. You can't do it. Stop now.
No,
Do you have an understanding as to the value of the first ring we were talking about earlier?
I was told several things, so I believe it's worth around 75,000.
Did Mr. Zeifman tell you that?
He did.
You'll see right here. Then you'll get some scummy attorney come in there and say, "Oh no, it was signed under duress." No. The only safe thing is to not do it.
With regard to the ring that we've just been talking about, ring number 2, do you have an understanding as to the value of that ring?
I don't really know. I wasn't aware it was lab.
Okay.
You can spend all the time you want with a woman. You can like a woman. You can take care of her. You can pay for her crap, but you cannot marry her. You also can't cohabitate with her in any state that recognizes common law marriage. You can't do it. It's not okay.
Let me bring up another document, Your Honor. It'd be Exhibit R3. Please present that. Do you recognize this ring?
Yes.
You can have children with her if you want to have children. You're biting off child support. But that beats the hell out of being married.
Both of those.
Is this ring the same as ring 1 or ring 2, or is this a different ring?
No, that's a different ring.
Okay.
Oh my God, are those her hands? Just no. I've got some standards, people.
Who took this picture? Did you?
Yes.
It accurately depicts the ring which was owned by you?
Yes.
Okay. Request to move
That's
this
at the
into-
compound. Sorry.
Request to move this into evidence, Your Honor.
No objection.
Admitted.
So is this the third ring that you received from Mr. Zeifman?
Yes. You'll see below there's a band that I received. But that is the third diamond that I received. Mr.
Okay, we're not here to discuss my kinks, but that right there is a hard no. It's just a hard no.
Burnett was there with his
Objection.
wife when I
Objection non-responsive.
yes.
Is Mr. Burnett and Mr. Zeifman friends, as you understand it?
Best friends.
So has Mr. Burnett been present on many occasions with you and Mr. Zeifman?
Yes, he and his wife have been present.
They've been to the compound?
They visit the compound several days a week, every week.
So is it your testimony that Mr. Burnett has seen you wearing this particular ring we're looking at?
Mr. Burnett, it is my testimony, has seen every ring that we're talking about on multiple occasions. And this ring, I know if you see my fingers really swollen because Clifford had ordered it
I
too
object
small.
to the non-responsiveness.
Yeah, Ms. Zeifman, I'm going to have.
Look at it. She's even trying to look at this. My hands are prettier than hers by a wide margin. Oh yeah. And my hands have actually done some work.
Have to kind of lead you down the path of what I'm looking for. And so what's the circumstances as you understand it as to why you got this ring from Mr. Zeifman?
I got this ring because, again, he said that ring number two, that he had put it in the safe with ring number one, and that this one was uh, just emotionally. He said that he was emotionally traumatized by that other ring as well.
It could be worse. It could be worse. You can lose all of that plus all your future income if you're in an alimony state. Don't ask me how I know.
And so he gave me this one.
Is this ring in your possession?
No,
Where's the last place you remember seeing this ring, which we'll call ring 3?
I remember the last place was at the compound in the kitchen.
And was that with Mr. Zeifman?
Yes,
Do you have an understanding as to the value of this ring?
I do not.
Do you have any access to get this ring or retrieve this ring as you sit here today?
No,
Was this a real diamond?
it was a lab diamond.
Did Mr. Zeifman tell you how much it cost?
No,
The first ring we were talking about, ring 1, was that a real diamond?
That got me.
yes,
How about ring 2?
no.
Okay, I'm done with this exhibit. If you can bring up R5.
You are incredibly lucky.
What is this?
I did not have that experience.
That's a ring that I made for myself. Well, it's my diamonds. It was made at Lee Major's Jewelry, and it's all the little diamonds that my grandparents.
Oh, good Lord. On top of being stupid and having ugly hands, you have horrible taste.
Parents or the parents had given me
What's not to love here?
over a lifetime when they could have.
So did you own this ring prior to your marriage with Mr. Zeifman? Either 1 or
Yes.
2? Yeah.
Yes,
Okay. I'm going to request to move this into evidence, Your Honor.
No objection.
It's admitted.
The whole design of that ring was to cover her ugly hand.
Did you regularly wear this particular ring, ma'am?
yes.
Where was the last place you remember seeing this ring?
In my silver anthropology jewelry box that I took to Clifford's on March 15th, 2025.
Did you say that this particular ring was in a box?
Yes, this ring was in a jewelry box. Yes,
Okay. Did Mr. Zeifman take possession of the box?
he did.
Did he say what he was going to do with the box?
Yes, he put it under the cabinet of the stool that Bobby was designated to sit at, and he said that Thomas would put it in to the safe the next day. He would have Thomas do that.
Who's Thomas? Just briefly.
Thomas is Clifford's everything man. So he sets up all of the security. He builds some properties. He reviews the cameras. He watches us.
He's someone that's employed by Mr. Zeifman. Is that your understanding?
Yes.
Okay. Do you have an understanding of the value of this ring?
Yes.
What is it?
It was appraised at $75,000.
Can you bring up R6, please? Do you recognize this?
Yes,
What is it?
it's a band. Uh, can you hear me?
Yes.
Okay. It's a wedding band that from a previous marriage that doesn't have a stone in it.
Where's the stone?
It fell out. It was a blue stone that fell out when in Clifford's home somewhere.
Okay, this isn't something, the stone isn't something that you're saying then is in Mr. Zeifman's possession or that he took that, are you?
No, I'm not saying that. It
But the
fell out.
ring, the band itself is, correct?
Yes.
Okay.
Yes.
And then the last place you saw that was with Mr. Zeifman?
Yes.
Okay. Do you know what the value is of this particular band?
I can't say for sure. It's a lot. It's
Do you have an estimate of what it is? Do you know how much you
um,
paid for it or how much somebody paid for it?
my estimate is about $30,000, $20,000.
Okay, what are you basing that on, ma'am?
Well, it's heavy, it's for platinum, and it has um, many diamonds all over it, different sizes. So it's not just pave, it's 1 carat diamonds as
Okay.
well, half carat. Actually, half, yeah.
Okay, let's
It
go
was
to, that's okay.
yeah.
Let's go to R6A.
And actually it was Ella's. I don't know. I've given it to Ella.
Well, actually strike that, Ms. Martinez. If you could go to R7, sorry. What is this?
That is my late grandmother's gold brick bracelet with diamonds on it that she gave me as my inheritance.
Okay. So this was something that you received from your grandmother in inheritance. Was this prior to your marriage with Mr. Zeifman?
Oh yeah.
Okay.
Yes.
Where was the last place you remember seeing this?
In the jewelry box with Mr. Zeifman on March 15th.
Okay.
20.
Is this true and correct, accurate depiction of what that bracelet looked like, ma'am?
Yes, and it's 12 point something 6 ounces of gold.
Okay. Do you have an understanding of what the value is of this bracelet?
Yes, I mean gold was what it is 5, it was 6, but the
How many ounces did you say it was?
12.6
Okay.
heavy times 6.
Okay.
So
Okay. And you don't have access to this bracelet, correct?
no.
I'm going to request to move this into evidence, Your Honor.
No objection.
Admitted.
Let's go to R8. What is this that we're looking at?
Those are 1 ounce gold coins. Except the other one is half an ounce, the one you see. My granddad gave those to me every year. My sister would for all through my childhood.
Okay. I'm going to request to move this into evidence, Your Honor.
No objection.
Admitted.
Where was the last place you remember seeing these?
In the silver jewelry box on March 15th, the compound.
And was it in the possession of Mr. Zeifman?
In the possession of Mr. Zeifman. He closed the box, put it in his hands. Yes.
Thank you. Ms. Martinez, bring up R11. What is this?
It's the silver jewelry box. Anthropology I had before it conferred. And it's the last time I saw my jewelry was in that box. What is it?
Okay. Is this the box that you've been referring to when you've described where the pieces of jewelry we previously looked at were located?
Yes, it's one of them. It's the main one.
Got it. And in this particular picture, is this an accurate depiction of what you remember? Did you, well, strike out, did you take this
Very.
picture?
Yes, I did.
Okay. So it's an accurate depiction of what you remember when you took the picture, correct?
Yes, my,
That's okay. Request to move this into evidence, Your Honor.
yes, that was all in it.
Any objection?
No objection.
All right, it's admitted. We need to go ahead and take our morning recess. I think court reporter's been on the record an hour and 45 minutes. So we're going to reconvene at 11.
Sure.
Your Honor, if we can get an idea at some point how much time council has used so far, because I assume we're each allocated half to 3 hours today.
That's correct. You'll each have an hour and a half. And Mr. Loverado, you're at 41 minutes. And Mr. Burnett, you're at 21 minutes.
Thank you, Judge.
All
Thank
right.
you.
We'll see you at 11. You're welcome to turn off your video until then. Thank you.
Big, this.
All right. Well, let's see if everybody's back. We need to make sure our court reporter's here. There she is. Okay. Mr. Loverado, you may continue.
Thank you, Your Honor. I think we were looking at that silver box. If you can bring up R11 again, please. Judge, I'm going to request to move this into evidence.
No objection.
It's admitted.
Ms. Zeifman, where was the last place that you saw this box? You're on mute.
The last place I saw it was with Mr. Zeifman in his kitchen.
Okay, did the box have the contents that we're looking at within it?
Yes.
Okay, tell us the circumstances of when and where the last place you saw it.
The circumstances were that he had told me to bring all of my jewelry to Churchill, to him, where he would put it away. So I handed it to him. And
Okay.
yeah.
And we're looking at this box. If you look at the top left, there's some coins in it. You see that?
It's
Okay, those are the coins that we were looking at earlier.
yes.
Okay.
And then it also in that rusted box.
I'm sorry.
Also in that rusted box, the
Okay.
middle one.
What is your estimate of the value of those gold coins?
7 ounces, 0.5, $35,000.
Is that based on the current price of gold?
Yes. Unfortunately.
And do you have an estimate as to the value of that bracelet?
Okay, she's dumb as a stump, and she's slow at answering any question, but she knows gold spot off the top of her head. Oh.
Ma'am, are you a whore?
Yes, it's about $75,000.
Is that based on the fact that it's gold and has diamonds?
Yes,
And did you say how many ounces that was?
12.67.
Do you know where that box with the contents is today?
the last time I saw that box was in Churchill in Mr. Zeifman's hands.
Okay,
He told me it was going to Medical Parkway.
got it. Let's go to R12.
A vintage jewel necklace that also I purchased at an auction for $3,500.
Okay, the box that we're looking at with the contents on top, is that an
Mhm.
accurate depiction of what you saw when you took that picture?
Yes.
Okay, request to move this into evidence, Your Honor.
No objection.
R12 is admitted.
The lion pendant there, do you have that in your possession?
I do have that in my possession. I took that one. He said I could take that one.
Okay. What's the circumstances of this particular box being in the possession of Mr. Zeifman, if that's what you're saying?
Same as the silver. I brought it at the same time. He wanted all of my nice jewelry.
Have you seen
So
it since?
no,
You can take this exhibit down, bring up R14, please. Okay, this is the passport of, I guess this was be of your daughter, concerning your daughter, correct?
yes,
Do you have this in your possession?
no.
Do you know where it last was?
In Clifford Zeifman's possession.
Okay. Um, does he have your passport?
He does.
Have you asked for these passports back?
I have.
And what were you told?
I wasn't told anything directly. That I don't have them.
The last person that you saw them with was Mr. Zeifman?
Yes.
Okay, you can take this down. I'm not going to move this into evidence.
In fact, he took the picture. So
He took the picture that we were just looking at of the passport?
yes, he texted it to me. It says from Clifford.
With regard to the passports, who usually maintained possession of them?
Ways Clifford maintained possession.
So did you all travel together, take vacations where you went abroad?
We did.
And when you did that, would Mr. Zeifman be the person to hold on to those and secure those?
Yes. Yes. At one point, it was really scary because he ran out of a hotel with all of our passports. But yes. And he would also have them in his possession when we went to Washington in case we went to Canada.
Okay. Ms. Zeifman, after you were separated from Mr. Zeifman, have you been back to the compound?
No, I haven't
Okay.
been
Have you
allowed.
had any access to any properties owned or controlled by Mr. Zeifman?
No,
Have you ever been allowed to conduct any kind of search regarding the items that you're asking this court to give back to you?
never.
Mr. Burnett, in opening, mentioned something about a yellow piece of furniture. Do you know what he's talking about?
Yes.
What is that?
It's an armoire I'd had for a long time that I didn't want to, there was donated everything of mine, but I asked that that be stored because my daughter wanted it
Okay.
and it's been
do
shipped somewhere
do
recently.
you have an understanding as to whether or not we've gone over to look at that piece of furniture?
We have not.
Well, last week we did, but maybe you weren't aware of that. Are you now
We didn't,
learning?
yeah, we didn't go to Riesel. Maybe I misunderstood. We didn't go to Riesel to look at it altogether. Did you mean?
Yeah, that's okay. As far as you know, when we went to look at this piece of furniture, was there anything in it?
No,
Is it pretty worthless piece of furniture or what?
no, it's not.
Okay,
No, it's
tell
not.
us what it's worth.
It's an Adele Kerr armoire that I got in Highland Park. It's worth $10,000.
Ms. Seifman, you're asking the court to return items of property to you, such as jewelry and things like that. Are you asking the court to do this so you can wear them around, or what's the purpose of your asking?
No, I'm asking for them so that I can pay my fees and I can get a divorce. I can't afford a divorce.
And are you currently experiencing financial difficulty at this point in time?
Extreme financial difficulty.
Have you been able to pay us your attorney fees?
Only a portion.
Now you're gonna cry. Where?
But
How
no,
much?
I've been able to pay about over 70,000.
Is there an amount still due and owing to us?
Yes, some
How much?
140,000.
And as you understand it, a major part of this case is whether or not the prenuptial agreement that Mr. Burnett was talking about earlier is enforceable or not, right?
Right. Right.
Would the return of jewelry or an amount of money for their replacement help you in supporting yourself and participating in this case meaningfully?
Yes, I can't continue if I don't get my jewelry back. I can't
Okay.
continue.
Did you say that you're doing things like, for example, cleaning houses to make ends meet?
Yes, I
How
am,
much
and my
are you-
daughter's working.
I'm sorry?
My daughter's working too.
How much are you asking the court to award in interim attorney fees?
Well, I leave that into the court's discretion. But if I owe you $140,000, I would say at least that amount.
And are you asking that the court order interim attorney fees prospectively? In other words, to the extent that we have attorney fees going forward to help you with your claims? Sorry?
Yes.
Your Honor, I'll pass the witness.
All right, Mr. Burnett.
Ms. Seifman, you have a college degree, correct?
Yes.
And you're a licensed therapist by the state of Texas, is that correct?
Yes.
Are you working as a therapist now?
I am working. I have 2 clients that I talk to once a month.
So you work a total of 2 hours a month as a licensed therapist, is that right?
4 hours a month. My data was all breached by your client, so I can't.
Objection, non-responsive. Just try to answer my questions. We went through this in your deposition. Just answer my questions, ma'am. You work 4 hours a month and you're a licensed therapist with a college degree, correct?
Yes.
Okay. And when I took your deposition last month, you had approximately $55,000 in your bank account, correct?
Yes.
And you testified that deposition that you just got a new job making 6 figures, correct?
Yes.
And Mr. Zeipman was not at that deposition, was he?
No, he was not in
All right,
person.
thank you. All right, thank you. And do you remember at the deposition, I asked you if you had any written documents showing that you were offered this job for 6 figures and you had accepted? You remember me asking you that question?
Yes.
And you remember you testified that you did have documents supporting that. You remember that?
Yes.
And I asked you to if you would produce those documents to me, and you said you would, correct?
Correct.
All right. As we sit here right now, a month later, you still have not produced any documents to me showing that you were offered this 6-figure job and you accepted it, correct? Yes or no?
A correction.
Have you
Well,
produced those documents?
I
to me?
haven't.
Yes or
I haven't
no?
produced documents to you, to my knowledge.
Okay.
All right.
Well,
The court reporter is waving. She's very frantic and upset with all of you. You need to speak one at a time. She cannot take more than one person speaking at a time. Thank you.
Why have you not given me those documents that you agreed to do so a month ago?
I wasn't aware that you did not have them.
Whose house are you cleaning now?
I'm cleaning for a service that where I clean several houses.
Okay, how many houses have you gone to clean since I took your deposition 1 month ago?
I just got hired, so only one. And
Okay, because you testified that you testified that you're cleaning houses to support yourself, correct?
yes,
And is it your sworn testimony that you have now cleaned one single house? Yes or no?
it not by myself, but yeah, I'm having to shadow.
Okay, where was that house located and when did you participate in the cleaning of this house?
No, no. In fact, I didn't even clean that one. I hired Lupita to do it, and I marked it up because I have rich friends. Because my ex-husband used to have money. I told you before we even got here.
My Joy is who my new boss is, and I showed her by cleaning her apartment because we live in the same area, and so I didn't get paid for that. But I only got this position last week.
Okay, ma'am, what's the name of this cleaning service you now claim to work?
This is such an obvious, plain as day lie. The attorney's doing a nice job of pulling it out without getting emotional about it. Just let her explain it. It's so dumb on its face. You don't need to like make a show of it. Just let her say it.
I'm going blank. It's I'm sorry, I'm drawing a blank.
You're drawing a blank.
Can I pull a card out to show you, or
Sure, pull the card.
Because you're not very smart, and your lie only had that one level. You're not trying to think up number two, and your brain doesn't function very quickly.
Card out and tell the court the name of the cleaning service that hired you to clean homes.
okay, it's I don't want to take up time. That
It's called BS. I completely made up services Inc.
to you at break, please.
That's fine. I think we understand what's going on.
Nope,
Now,
I
isn't
have
it
it.
true, ma'am? Ma'am, you've not cleaned any homes, have you?
Yes, I've cleaned her home.
Okay.
How did I know? She hasn't even cleaned her own house since she's known this guy. Give me an effing break.
Okay.
Yes.
Is the home you're saying you cleaned your employer's home?
Yes.
Okay. And the lady who owns the cleaning company, you went and cleaned her house?
Her apartment. Yeah, to train. I'm in training.
Okay.
So
what is that lady's first and last name?
she just moved in. Her name is Joy, and I'm drawing blank. But I can't look at my phone, right?
No, can you remember her last name?
Not this moment. I'm flustered.
What does she look
But
like?
I have her phone. She's 60. She's in her 60s, and she has gray hair, and she lives in my complex.
She's flustered and stupid, but mostly stupid.
And so how did you meet this lady?
At the swimming pool at my apartment complex.
Okay, I have to do it.
Can I say the words that she said, or?
Sure. I need for you to tell me what went on.
That I'm not on that whole shit. I'm not with that whole shit.
She said she had small cleaning business, and I asked her if she needed any help, and she said yes. And she said that she had.
I'll take things that never happened for 500.
One of her cleaners was not able to clean anymore, and so I would be training under Maria, who's our longtime cleaner, and that I would be assigned clients, and if I could find clients, that I would.
Sorry for using that stereotypical name. It wasn't Lupita. It was Maria. I'm so ashamed.
That I would have be able to use those two, and if they book 3 times, then I would get $50 referral fee.
Now, you and Mr. Zeifman got remarried for the second time in December of 2022, correct?
Yes.
And since that time, you've always had a separate place that was leased for you in Austin, Texas, correct?
Clifford and I have
Objection non-responsive. Try to answer my question.
Because no, I am.
Yes or no? Since December of 2022, when you got married for the second time, you've always had a separate residence in Austin leased on your behalf, correct?
No.
Okay, when did you not have a separate residence since December of 2022?
I did not have any separate residence. Clifford was on a lease, or he owned the property. And when I was on a lease in 2 places, he threatened to, sometimes he wouldn't make the payment. He'd take himself off, and I couldn't afford to stay there. I didn't have anything or anywhere. And
okay, let me try to simplify this.
Can tell you that the apartment complex, my landlord.
All right, let me try to simplify this for you now. Since December of 2022, isn't it true that you've always had another place in Austin where separate from this so-called compound that you call it, where you had a key to the front door where you can enter that place? Yes or no?
Aside from sometimes, but yes.
Okay.
I had, yes.
Okay. And it's your testimony that in March of 2025, when you previously testified you were living in the compound, Mr. Zeifman told you to bring all this valuable jewelry from your residence on Bunnell Drive to his place. Is that what you're telling us?
Yes.
Okay. Well, if you previously testified you were residing in the compound, if you're residing in the compound, then why did you have all this very valuable jewelry in this residence leased for you on Bunnell Drive?
Well, it was purchased by Clifford, so it belonged to him too. It didn't belong to me. And when I had, he didn't like it when I had it at the Grove as well. My jewelry that was separate than what he had given me, and so he kept kind of pushing, but the Grove was safe, and so I moved everything to Bunnell, and we were moved around 6, 7, 8 times. And he brought it up. So like, bring it over. It's not really safe there, but I was there. I was living there a lot, you know.
Okay, it's pathetic because this guy is manipulating her. He doesn't give a crap about this shitty jewelry. He doesn't. There might be a couple $100,000 there. That's nothing to him. Nothing. He's just using it to manipulate her, which is going to make a bunch of people cry, but literally that's way nicer than he should be. But what it says to me is that he is conscious that he is a walking ATM to her. And why the hell is he putting up with this crap? Why? My God, give her $1 million and tell her to get lost. Move on with your life and enjoy.
I was there, wasn't in the daytimes, but we slept at Bunnell a couple of nights a week. And so he asked me, and when he finally said in March this all needs to be
Also true.
secured in my office at Medical Parkway. So that's why.
Well, if you're living, my point is, ma'am, if you're really living at the compound, why did you ever even take all this jewelry that you claim is worth over $200,000 to this residence on Bunnell Drive? Why did you do that?
First, I took it to Riker. I had it in my possession the first time that he surprise divorced me. And then I moved it to the Grove, to Riker. These were safe places. And then when I moved to Bunnell, it wasn't, according to Clifford. Is that your question?
Now, no, I don't think you can answer it. But this Bunnell residence that you're talking about, that's the residence that was on your daughter's school records for where she resided, correct?
No.
What residence? Your daughter goes to Anderson High School, correct?
Yes.
And Mr. Zeifman, the compound is not within the Anderson High School school zone, is it?
The compound is not.
Right. So what address did you use for your daughter to be able to go to Anderson High School?
Mr. Zeifman provided me with a lease for Quarry Lane, which is where Quarry Lane, something he owned, and he gave me a lease to sign, and that's what I presented.
All right. Now, this residence, Bunnell Drive, where you say all this valuable jewelry was at until March of 2025, had a security system, correct?
I think they both had that thought. I can't imagine these people don't like each other. I don't think they did then. I think they got remarried to renegotiate the first divorce, both thinking they would end up better off than they did the first time. Can you think of a better indictment of the institution of marriage than that?
Oh, yes, it did.
Right, right. So this unsafe place had a security system through ADT, correct?
Yes.
And it also had Ring cameras, correct?
Yes.
Okay. Now, Mr. Zeifman filed for divorce I guess the third time now, in September of 2025.
I couldn't fake it. I couldn't fake it for 10 seconds. I couldn't. Just take it. Don't talk to me. Period. Whatever.
Correct?
Yes.
All right. And the first time you ever made a claim or demand for the return of these items that we're talking about today was in late February of 2026, correct?
Incorrect.
Well, what records do you have where the demand was ever made before February?
I do. And let me tell you, they're just as stupid as everybody else. When I say just as stupid, they're not all stupid and they're not all smart. But in about the same proportion, they do dumb crap. They just have more money. Really, that's the difference.
Of 2026.
Well, I have records of that I sent everything. I sent all of my jewelry that was missing at the same time that I sent everything, my clothes. So
I am not jaded. I am spot on.
So I sent it all at the same time. But since I didn't have anything to wear and it was cold, the immediate focus was we need our clothes.
Objection non-responsive. Isn't it true, ma'am, that the first time that your lawyers gave me a written notice that Mr. Zeifman was in possession of this valuable jewelry you're talking about was on March 2nd, 2026, correct?
I do not know. I provided my lawyers with the information in October of 2025.
Okay, well, if you look at petitioner's exhibit number 9, you recognize these emails between your lawyers and myself? If you can share the screen, Ms. Young.
She can share.
You're on mute.
Pulling it
Can
up.
you share yeah, petitioner's exhibit number 9. And if you go to the 3rd page of this email.
Your Honor, I might have missed something, but I didn't see any exhibits provided in connection with this hearing from petitioner.
Yeah, we loaded them in the box this morning before the hearing began. All right, do you see that email there?
Yes.
It's to me
Mm-hmm.
from your lawyer, Ann Wynn, correct?
Yes.
And what is the date of that email?
It's hold on, I'm trying to see the date. I'm sorry.
Here, I'll help you out. You see where it's dated November the 11th, 2025.
I just scroll down. I don't see. Okay.
It's right there.
Okay.
Your Honor, I'm going to object this hearsay.
Well, I don't think he's offered it yet, so.
I'm just objecting to him asking questions, but that's fine.
Do you see the date of this email, November 11th, 2025?
I'll see where it is, where the date, it says the date.
Okay. Your Honor, I'm going to offer these emails into evidence.
It's hearsay, Judge.
That's fine. I can call Miss Wynn to testify that they would really want me to do this.
Well, then, I can call you to testify because you're a fact witness in this case big time. So I didn't think we were going to go there, Mr. Burnett.
Well, I mean, you're objecting to hearsay emails that I get from your office asking for her belongings.
Judge, it's hearsay and it's documents that my client's not even on. So
I'll sustain the objection.
Isn't it true, ma'am, that last year in 2025, you're not aware of any written demands from your lawyers to me asking for any of this jewelry back, are you?
I was under the impression that there was a demand to you.
Okay, and have you seen that demand?
No, I just have provided the information.
Okay, so when you're under the impression that the demand was made to me, are you just guessing?
No, I was told that to send everything that was missing. And so I did. And then I was told that first.
Yeah, that's the ticket. I was told that while I was cleaning a house.
The first focus was going to be on getting us some clothes to wear.
Okay.
We didn't have anywhere to live either.
Did you have a chance to read your lawyer's first amended motion to compel that this was filed in this case?
Yes, I believe so.
And did you see attached to their motion as Exhibit A, an email from your lawyers to me on March 2nd, 2026, demanding the return of this jewelry that we're talking about today?
Yes.
All right. Have you personally seen any written demands that predate March 2nd, 2026? Yes or no?
No, just mine.
Okay. And just yours, to be clear, your communications with your lawyer, correct?
Yes.
You don't have any, you don't have any written communications from you directly to Mr. Zeifman demanding the return of any of these items, do you?
I do, but not.
All right, where are those communications? Remember, you're under oath, ma'am.
They're with my attorney's office.
Okay, so are you testifying under oath that you have a copy of communications, either emails or text messages from you to Mr. Zeifman since March of 2025, demanding the return of these items that you say you left at his house? Yes or no?
Yes, I have communicated that I want those items back to him.
Ma'am, are you a whore?
And did you communicate that in writing is my question?
Yes, and texts and yes.
Okay, why haven't you produced those text messages?
I am happy to. I don't.
Truth is, you don't have them, do you?
No, that's not the truth.
Okay. It is true that you've had your own state.
No, Michael Burnett is your name there. I think you've got it. I think you've got it sussed, my brother. Go Michaels.
Safety deposit box at Chase Bank, correct?
No, I have one.
Okay, since December of 2021, when you married Mr. Zeifman for the first time, have you ever had a safe deposit box at Chase Bank? Yes or no?
I believe it was closed the next month.
That last comment was a combination British and American street talk. You're welcome.
After we married, he said it was too expensive. I couldn't afford it.
You think it's strange that you got these pictures of this jewelry in your jewelry box and you with a ring out like that? I mean, do you think that's odd?
How do you mean?
Well, do you think most people go out and take pictures of their jewelry boxes that they have?
I don't know. I take pictures of everything.
She's taken a lot of pictures of her box over the years.
And is it odd that I took pictures of my jewelry boxes with jewelry? No, I like to, it's important to stay organized about what I have and where it is. So, yeah, no, I don't think it's odd at all. As far as on my hand, took a picture to send to someone to show them.
All right. Response exhibit number 1 was a picture of the ring that you claim Mr. Zeifman has possession of that's worth how much?
$75,000.
Okay. And you testified that the last time you saw this ring was in early 2023 when you were in Portland with Mr. Zeifman, correct?
Yes.
Okay. Isn't it true, ma'am, that you've only gone to Portland with Mr. Zeifman one time in your life, and that was in December of 2021?
No.
How many times have you gone to Portland with Mr. Zeifman?
I've driven through to take his kids to camp.
What part of with him don't you understand? I mean, this is an easy one. If you don't go there a lot, you should be able to name the number. I think we had that one super special starfish experience, and that's it.
We've I don't know, maybe 8, 10. We went to look at some property. He bought a trailer home park, and this trip I was suffering from a concussive disorder. I hadn't even so.
Oh, you've got to be shitting.
I hadn't even started physical therapy yet.
You're testifying under oath that you've taken more than one trip to Portland with Mr.
Your Honor, I am a neurodivergent person with complex PTSD.
Zeifman.
Yes.
Okay. Now, the other diamond rings that you've talked about were lab rings, correct?
Yes.
Okay, and a lab is a human-made diamond, correct? And in fact, the second ring you had was a 10-carat lab ring that he purchased at your request, correct?
Not the second ring I had, and it's 9 carat.
9
It's the
carat.
last one. It's the one I still have in my possession. Yes.
Okay, but the first ring you said was worth $75,000. The second ring.
Oh my God. I know this guy's got money, but he is overpaying for substandard quality.
That was a lab ring, correct?
Even if it's fake.
Yes.
She's not worth 9 carats of CZ, man.
I didn't know it, but yes.
Now, the exhibit number 7 is the bracelet, correct? You remember that?
My gold bracelet?
Yes.
I don't see the exhibit, but yes.
And
only on Law Talk with Mike do we really get to the nub of the issue. Other places yammer on about law stuff, blah, 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 blah. And they get it wrong. No. We get to the issues that matter here. He had a Groupon.
And that bracelet has little diamonds on it, correct?
Right.
And how much is that bracelet worth?
It's worth, depends on how much gold is worth, but, you know, $40,000.
And you test, do you have an appraisal for 40,000 or is that just your guess?
I have an appraisal, the original appraisal from my granddad giving it to my grandmother with, and so I had that reappraised based on that.
That's right. And you testified that you inherited this bracelet from your grandmother, correct?
Yes.
Correct?
Correct.
And it's your sworn testimony that the last time you saw this bracelet was in March of 2025, correct?
The last time I saw that bracelet was in, yes, in Mr. Zeifman's possession.
And that was in March of 2025. Correct?
Yes.
Okay.
Correct.
Isn't it true, ma'am, that your grandmother died just 2 months ago?
Yes.
All right, so you
No,
inherited
not
this
2 months
bracelet.
ago. I'm sorry. She died she died.
That fake, yes, with the like trying to sound sad, and then she has it wrong. God, just somebody yank her already. Give her the hook.
A few months ago, like April.
She died after you supposedly took this bracelet to Mr. Zeifman's house in March of 2025, correct?
Yes.
So you inherited this bracelet before she died? Is that your sworn testimony?
Yes, she gave it to me. She gave every one of us, the cousins and my aunt, something special from something that my granddad had given to her. She's in her 90s, that she wanted us to have. She gave it to us.
Now I got the pumpkins in my head again. Thanks a lot.
Years ago. I didn't just get it.
Yeah.
So,
Now your daughter's passport, Vivian's passport, it's true that she's not been to Washington State at Mr. Zeifman's home up there in a long time, correct?
correct.
I mean, how many years has it been since your daughter Vivian has been to Washington State?
Couple.
Well, in
No.
2000, she didn't go in 2025, correct?
No.
And in 2024, she went on some international trip paid for by Mr. Zeifman, correct?
Yes.
Okay. And so she didn't go to Washington State in 2024, did she?
I don't know. I can't recall. We were around a lot. We were supposed to go, then not. I don't recall.
Now, when your lawyer sent the request for your clothes and other items, Mr. Zeifman had 5 or 6 boxes of items delivered to your lawyer's office, correct?
Yes.
And since that time, he has told you that any belongings you had and properties he owned in Sweetwater and Midland have been boxed up, placed in storage, and you can get them whenever you want, correct?
No, I've been told that in writing by him that I'm not to approach any of these properties, not to step foot on them, including for my grandmother's funeral.
Well, are you aware of, have you received copies of the course of the several letters I've sent to your lawyers saying, let me know when you can want to go pick up those items in Midland? Have you seen those documents?
I'm aware that they were sent. And but again, I'm not allowed to be on the premises, and he calls police. So,
well, sure, but you understand it's something that your lawyers can arrange for you to get, just like they arranged for you to get items last November, correct?
my items last November were.
Right.
We want to discuss what those were.
No, I just that's not my. Hold on, ma'am. That's not my question. My question is when your lawyers have asked me to get you items that we have, I've accommodated that, correct?
You have not.
All joking aside, this attorney is absolutely excellent.
Well, we had boxes of your stuff sent to your lawyer's office last November. Yes or no?
Some of it was my stuff. Some of it wasn't.
Oh, okay. Well, there were boxes of items sent to your lawyer's office last November.
There were boxes of items sent to my lawyer's office. Yes.
All right. And your lawyers asked if they can go to Mr. Zeifman's office building to examine this yellow piece of furniture. You're aware of that?
Okay.
And you aware that your lawyers went over there, set a time with me, and went over there and looked at it. Are you aware of that?
I just don't recall this time.
Are you aware that I've told your lawyers they can get that piece of furniture anytime they want?
Yes. Yes, I am aware.
Okay. And as we sit here right now, you haven't done that yet, have you?
Well, I can't afford. I don't have any money to have it put anywhere. I don't.
Well, yeah. A month ago, you had $55,000 in your bank account.
Sure. That's all I have. That's everything. It's everything. I don't have everything was taken. My daughter's college account.
Objection non-responsive.
He took it away.
Mr. Zeifman didn't take your daughter's college account, did he?
Yes, he
Remember,
did.
you're under oath.
I remember. So are you.
All right, look at exhibit number 4, petitioner's exhibit number 4. Have you seen a copy of this letter that I sent to your lawyers on March 17th, 2026?
Yes.
All right, and do you see where in that last paragraph, I notified your lawyers you do have some personal items in Midland and Sweetwater which have been placed into boxes. You read that, didn't you?
Yes.
And then I said, please let me know a date and time for when your client would like to retrieve these items, correct?
Yes.
And as we sit here right now, you've not taken any effort to obtain those items, whatever is in those boxes in Midland, to get them back, have you?
Your Honor, I'm gonna, let me make my objection, ma'am. I'm gonna object on the grounds of relevance, and also this largely lacks foundation unless he's trying to say that some of these items I'm requesting are in these boxes. What's the relevance?
Well, the relevance is that.
I'll overrule the objection.
Okay. Go ahead, ma'am. As you sit here right now, have you made any effort to get those boxes from Midland? Okay, what have you done? Tell me.
Yes. Right before my grandmother died, and then when she did die, she had asked us to host her, the people, the family and friends who went to Sweetwater for her burial at our house, at our home there. And I asked to please have access to the house and to retrieve her pictures and her things. And I was told, or through you, my attorneys, that I was not to step foot anywhere near the property. And I also asked the caretaker, Vivian, if she would be able to get some things out. And she called Mr. Zeifman and he said,
I object to the hearsay. You're not allowed to testify what someone else said.
I tried. That was my try, and that's what I heard.
Isn't it true, man? The deal you're talking about now is you wanted to go spend the night in Mr. Zeifman's property out there, and he said, you're not going to spend the night in my property. Isn't that true?
No.
All right, look at it, petitioner exhibit number 5. Did you get a copy of this letter that I wrote to your lawyers on June 15th?
Yes, I did.
And in this letter, I've said again, if you want your stuff these places, just let me know, correct?
You sure have.
Are you aware of any communications in writing from your lawyers to me responding to these offers for you to go get your stuff?
I don't believe these are offers, but no.
Okay.
Also,
she just gets worse and worse. I don't understand this. I don't understand. I'm just hearing this from the chat, but I don't think you guys are lying to me that this guy's got like billions of dollars. I don't understand how this guy didn't figure this out and buy his problem by now. I just don't understand it. She has no redeeming characteristics that I can see. She's not ugly, but she's not attractive. And she's dumb and she's annoying and she's a liar.
the Cadillac. Okay.
Excuse me, you need to wait for my question. So these, adding up the values of these items, there are over $210,000 of items that you claim Mr. Zeifman has possession of, right?
Yes.
Okay, and you didn't demand these requests until 5-6 months after he filed for divorce. That's correct, right?
I answered your question.
Now, in this case, you're challenging the prenup, is that correct?
In this, yes, I am.
Right.
In this, not this today, yes.
Right, I understand, but in this pending divorce case, you're challenging the prenup, correct?
Yes.
And the first time you got married to Mr. Zeifman was in December of 2021, correct?
Correct.
And he sued you for divorce 5 months later, correct?
Oh my God, he married her in 2021. She wasn't hot in 2021, I guarantee that. Sometimes these guys, they just can't function that. They're very competent in one way of life, but and just because they're so busy and stuff, they haven't developed any skills and they don't know what they're dealing with, and they go talk to a woman and this shit happens. It's pathetic. It's embarrassing.
Yes.
And in that first divorce proceeding, you hired a lawyer to represent you, and her name is Daryl Wyman, correct?
Clifford and I agreed on a lawyer to not to.
And I'll be back to New Zealand. I love New Zealand, but I only was on the North Island. I need to do the South Island. It's where the cool mountains are.
Divorce for a divorce, but to help us reconcile what he said was
but that flight sucks. I'm not going to lie to you.
Indefensible prenup that a marriage wouldn't work with something that unconscionable, and that he only had it in place because we did it like the day of, and he never thought that he would want to divorce me.
Objection non-responsive. Ma'am, the court has taken judicial notice of that first divorce case, which means the court knows what's in those pleadings in that case. You understand that?
Okay.
Okay, and in that first case, you were represented by Daryl Wyman, correct?
Yes.
And I represented Mr. Zeifman in that first divorce case, correct?
Yes, but Mr. Zeifman
Excuse me,
you
just got to answer my question. And in that first divorce case, Miss
Elon gets it. He does, but he doesn't marry him. He knows it's transactional. He throws him some money. He moves on with his life. It's just a lot better for everybody involved. Her, him, everybody.
Wyman filed a challenge to that prenup on your behalf, correct?
Yes.
She alleged that the first prenup was unconscionable and you signed it under duress, correct?
Yes.
Okay, and that's the same allegation you're making for the second prenup in this case, correct?
Yes, but also
You've
some
answered my
forgery.
question. You've answered my question.
Yes, that's a hike. When I flew to Cape Town, I flew from Amsterdam, and hell, that was a long flight. But I did get a couple hours in between after flying from the States to Amsterdam, and then I flew down there, and I'm like, damn, this Africa is a big continent.
And
Well,
then
no.
Well, are you challenging the prenup in the present
I
case?
am.
Okay,
I am.
on what basis?
On those that you said, the unconscionability and the I'm also challenging it on basis of it's not my signature on a lot of the document. It's not valid. I didn't there are pages I didn't initial, and there were amendments I didn't see, and I didn't know I didn't have that. I wasn't under the impression that I was signing a prenup.
Not only are you college educated, but you testified in your deposition last month that you completed a year of law school at SMU, correct?
Yes.
And in fact,
25 years
you've
ago.
you've been tested in the last couple of years where it has shown you have a very high IQ, correct?
I do.
In fact, I think according to one of the tests, your IQ is in the top 5% of all people in the.
I do not believe that. I simply do not believe that. That is not possible. That's all I'm going to say.
United States, correct?
Well,
Do you remember that test?
Clifford's
I
had me
didn't hear
tested.
that.
All right. Well, look at exhibit number 3. Petitioner's
Okay.
exhibit number 3.
Michael, it's fine. I'm sure that's an IQ range. We don't, sure.
Those are the
right.
questions.
Well, look at exhibit number 3. This is the second premarital agreement that you've executed, correct?
Yes.
And if you go to page go to page 20 of 21. That's your signature, correct?
That one is.
Right. And if you go to the next page, it's notarized, correct?
Yes. My
You
signature.
signed this contract before a notary on December the 21st, 2022, correct?
I signed some of it. And I was on hydrocodone and sumatriptan, and I had a concussive disorder. I knew we were getting married. He had said he was doing everything differently, and I didn't know. I thought these were marriage papers, but no, I didn't sign certain pages on here.
Well, you represented in this agreement that you had an opportunity to read it. You remember that?
The opportunity? No, the day that he decided we were going to get remarried, all I remember is a text where he said he was on his way to pick me up, and he sent some kind of document, and then picked me up and drove me to, it was not Bastrop. He drove me to Hayes County, and I was.
This today, Your Honor, my health is in jeopardy right now.
What's that?
I have IBS, irritable bowel syndrome, and what's been going on is
Very stressful.
I'm bleeding inside, ma'am.
And on that ride to Hayes County, he said this was all, all going to just be really different. And he messed up the first time, and he was so sorry. And then when we got there,
oh, he messed up both times. Is this guy blind?
there were papers to sign, but there was no we didn't talk about them or anything.
Well, look at page 19 of this document. And Your Honor, I need to offer this into evidence.
What's the exhibit number?
3, petitioner's exhibit number 3.
Any objection?
No objection.
Admitted.
Look at page 19. You see all those representations that you made?
Uh-huh.
You represented that you entered into the agreement voluntarily. You see that, B?
I do. I recall standing on my walker and having to sit down and just initial. So yes, I see that.
Okay.
You reached an hour, Mr. Burnett, just so
Okay.
you know.
All right, thank you, Your Honor. And then did you also understand that, or you do understand now, that in this agreement, you waived any claims you would have in the past or in the future against Mr. Zeifman's separate estate? Do you remember doing that?
I do not remember doing that. I am aware of that now.
Okay. And this prenup is substantially the same as the prenup you executed in December of 2021 that you claimed was unconscionable, correct?
Yeah, correct.
I mean, the first prenup is exhibit number petitioners 1. You can put that up, Ms. Young. You see that?
The first one that I signed in your office
Right.
2 hours before our wedding, you mean?
Right. And do you remember signing this?
Yes.
In fact, do you remember telling me that you would sign a prenup that was on a blank piece of paper? You didn't care. You just wanted to be with Mr. Zeifman and you didn't care about his money. Do you remember saying that to me?
Yes.
You remember sending me a text? So you remember saying that? And if
I
you
do.
look at petitioner's exhibit number 1
Oh, no.
on page 17, that's your signature, isn't it?
Mr. Zeifman told me something different. That's why I said that.
Excuse me, just answer my question.
Yes,
Is that your
that's my
signature on page 17 of petitioner's
It is.
exhibit number 1? Your Honor, I offer petitioner's exhibit number 1.
No objection.
Admitted.
Can everyone please not talk over each other, especially with Zoom? We need a little bit of a break, please.
My apologies. Now on petition, Your Honor, is exhibit number 1 admitted?
It was.
Okay, thank you. And petitioner's number 1, the first prenup had detailed information attached to it about Mr. Zeifman's assets and the values, correct?
Yes.
Okay. And you read that information before you got married to him the second time, correct?
No, I hadn't read it the first time.
Okay, so is it your testimony that when you're going, after you executed the first prenup and you were going through the divorce in 2022, when you were challenging the validity of that prenup, that you never read the document? Is that your testimony?
Yes, our couples counselor told me to go read it and gave me safe place information. And that was in February of 2020.
I just want to make sure the court understands your testimony. It's your testimony that you never read the first prenup that had all these waivers, disclosures, and releases before you challenged the validity of the document in court filings?
No, I had read it.
Exactly,
I
that's
didn't-
my point.
No.
I'm
trying to answer your
Let me make
question.
sure you're not. Isn't it true, ma'am? Before you executed the second prenup, that is substantially the same as the first prenup, you had read the first prenup, yes or no?
Yes,
Thank you.
that was the whole
You've
point of
answered my
contention.
question. Objection.
Why we
numbers.
divorced.
Sustain.
Your Honor, I need to reserve the rest of my time. I'll pass the witness.
Okay. All right, this is probably a good time for us to go ahead and break for our lunch recess. Do we, normally we reconvene at 1:30. Is that, does that work for everybody? Is there a reason for us to reconvene any earlier than that?
1:30 works for me, Your Honor.
Whatever you tell me works for me.
Okay. All right. And you've used an hour and 4 minutes, Mr. Burnett, and Mr. Laverato, you are at 52 minutes.
Got it. Thank you, Judge.
Okay. We will take our lunch recess. I'm going to reboot my computer because I'm having a few issues, so don't be worried if I'm not on. You're welcome to stay logged on or to log back in at 1:30. Either way, we'll see you then. All right?
All right, thank you, Judge.
Thanks, Judge. Goes for that armoire that Mr. Rings of Mr.
All right, welcome back. Just give everybody a moment to turn on their cameras. All right. Before we go on the record and proceed, I just wanted to share a couple of things with you. My court reporter is having a very hard time keeping the record. I need the witness to wait until the question is completely asked.
I got something
Do
to
not
share.
interrupt, and then you may answer. Zoom, it's very difficult. We need to leave a pause in between the question and the answer. So if everybody in the courtroom could endeavor to work on that, Ms. Simon and myself, we would greatly appreciate it. Second thing is, when there's an objection, the witness needs to stop. The lawyers need to stop. I can't rule on objections if y'all just continue to talk. Okay, and so there have been several occasions this morning where I didn't provide a ruling because really I would have been talking over someone else. And I'm trying not to do that. So if we could all endeavor to do that, it'd be much appreciated. This is your record. It's as good as your behavior. So let's try to be on our best behavior. All right, with that, we'll go back on the record, and Mr. Burnett, you may pick up where we left off. Or you passed.
Yes, Your Honor.
That's right. Okay, so Mr. Laverato, you may proceed.
Thank you, Your Honor. Ms. Seifman, earlier you were being asked by myself and Mr. Burnett about that gold bracelet that your grandmother gave you. Remember that?
I do.
I think the word inherited came up. That might have been yours or mine. I'm not sure. Bottom line is your grandmother gave that to you when she was alive, correct?
Yeah, she did.
And she's no longer alive now.
No.
Got it. Okay. There was a line of questioning that Mr. Burnett went over with you, and it had to do with your IQ. Do you recall that? Yes?
Yes.
Did you have your IQ test taken at some point?
I wouldn't put it past the attorney Burnett, because he's good, to find that, to know that it was like fraudulent. She made it up or had it done, and then still cram it down her throat, because her options are to stay with the lie or get caught. I wouldn't doubt that.
Yes, I did.
And was that test or the results of that test
She has all the credibility of tonsil twins.
provided to Mr. Seifman?
Yes, they were.
Was it provided to anybody else?
To Michael Burnett.
Okay,
And
why did you have your IQ test taken?
Clifford insisted that we all have our IQ tests taken.
What do you mean by that? What did he say?
He said that IQs were very important because we needed to, he needed to assess if, we could cut it or not.
He needed to assess whether you guys could cut it or not.
If you have a high IQ, why are you so freaking stupid? That's my question. That, and of course,
Ma'am, are you a whore?
Yes.
Were those his words?
Yes.
So who was tested?
All of us, me, my children, his children, all of us.
Is your understanding that he had all of his children tested and all of your children were tested, correct?
Correct.
Well, why did you allow your kids to be tested?
I think maybe a better question is why wouldn't I?
God, she's stupid. Okay, we're not playing what you think is a better question. We're in court testifying, and he asks the questions, and you answer them. If you had a higher IQ, you might figure that out.
Okay.
Well,
why would I
explain that.
allow? I didn't have an option. When Mr. Zeifman made demands and they weren't followed, then we had to follow them, or else he would lock us out. He would throw us out the door. He would berate me and my children. He would and the IQ, it was like to determine, it's like a pedigree system. Who, as far as cut it, who can make it in his home and who cannot.
Now here we are with the whole victim thing. I don't know if this guy did anything. She acts like he's like all tough, but he married you twice. And you were substandard from the get. The guy is, in the broader scope of things, way too generous.
Make it in his home.
You just testified that he would berate you. Did I hear that correctly?
Yes.
And you understand that Mr. Zeifman had his deposition taken, right?
Right.
Okay. And in that deposition, do you remember whether or not there were recordings of Mr. Zeifman berating you played in front of him?
Yes.
How many recordings are you aware of that you have of Mr. Zeifman yelling and berating you?
Dozens. A dozen.
Ms. Zeifman, do you have any diagnosis as it relates to your mental health?
Yes.
Your Honor, at this point, I'm going to object to this line of questioning. I've requested her mental health records and I've not received any. And so I think it's improper, and also object to the relevancy of this at this point, especially since I don't have the documents to cross-examine her.
Okay, sustained.
I think the real problem is this.
Meaning she was bleeding out of her hoo-ha.
As far as your ability to search for these items that you are now requesting the court to order him return, you don't have any access, correct?
I have no access. When I sent Mr. Burnett a copy of my medical records. So.
Have you had any oral communications with Mr. Zeifman prior to your separation? Strike that. I'm sorry. Let me ask this question. There was a line of questioning regarding some boxes over in Sweetwater. Do you remember that?
Yes.
Just briefly tell us what the property is over there in Sweetwater and what that's all about. Briefly.
It's not much. There's hardly really, there's nothing really valuable there. Some clothes, some swimsuits maybe, and some books, but nothing very valuable.
As you sit there today, are you satisfied that what's in those boxes has nothing to do with the items that you're requesting that the court have returned today? True?
Yeah.
And the same thing goes for that armoire that Mr. Burnett was talking about, that yellow piece of furniture at Medical Parkway.
Right.
Do you have any doubt that there's anything with value in that?
No, it's empty.
With regard to the prenuptial agreement, Mr. Burnett went over 2 of them with you. Remember that?
Yes.
The first prenuptial agreement, which I believe Your Honor and his petitioners won, that had attached to it disclosures, some financial stuff in the back, right?
Yes.
I didn't hear that.
Yes, it did.
The second prenup did not. Is that correct?
Correct.
Both of those prenups were prenups that you signed on the day that you got married to him, 2 times.
Yes.
Do you recall, with regard to prenuptial agreement number 1, and specifically those attachments, the disclosures, I'll call them, what Mr. Zeifman's alleged net worth was?
I recall that was $989 million.
Was there any information related to Mr. Zeifman's net worth attached to or incorporated in prenuptial agreement number 2?
No.
Okay, and part of your claims in this case is that he didn't properly disclose what he should have as it relates to prenuptial agreement number 2. Is that right?
Yes, and he misdirected. He not only didn't provide the information, he represented that the document was whatever, it was just totally different, a whole new marriage with, because no marriage would work with the first prenup.
Let me go back to the IQ question and then I'm going to be done. You said that you sent the IQ test results to Mr. Burnett. Why?
It was at Clifford's advice, his directive, after Clifford said Michael was very upset with me for trying to have him disqualified in the previous divorce, and that it might show him that I was trustworthy if I texted him my neuropsych reports.
It's a fraud. I mean, I don't know. I wasn't there, but my gut tells me this is a fraud. This is tonsil twins ultrasound report all over again.
Did you share the results from the IQ test related to your kids with Mr. Burnett?
No.
Was it just yours?
Just mine.
I'll pass.
Okay, when did Mr. Zeifman supposedly ask you or tell you or instruct you to have your children IQ tested? What year?
Several years. 2021. Everett was tested several times. And Vivian was tested in, I believe, 2023. That was several years ago.
All right, your son Everett, he had series tests done because he has special needs, doesn't he? Yes or no?
No.
Are you testifying your son does not have special needs?
I'm testifying that my husband made up a condition that he had, and that was not real. And So he does not have the special needs as is. No, he does not.
Well, who has primary custody of her son Everett?
Technically I do, but he elected to live with his dad in West Texas most of the school year, so he's mostly there.
Yeah, he's rarely in Austin, correct?
I see my son about once a month.
Right.
Hell yes, live with dad at the compound. Without her, fantastic.
Once a month. Now, Vivian, are you testifying in front of the judge that in
Son knows where the bread's buttered.
2023, Mr. Zeifman insisted that she get IQ tested? Is that your
I
testimony?
don't know that it was 2023. They were both tested. She was tested after he was, but yes.
Okay, yes. All right, thank you. All right, who did the IQ test on your daughter, Vivian? What's that doctor? I mean, what is that professional's name?
Dr. York.
Dr. York, and you have a written report.
Yes.
Okay. And now you have another daughter who's older, correct?
Yes.
Ella's her name?
Ella.
Did she get IQ tested too?
Ella had already had neuropsych testing done, fourth grade, and for her, she has severe ADHD. And anyway, her IQ was already done and tested, but Mr. Zeifman did tell me to give him. He said he needed those, so he has that record.
All right, just be clear, because we're going to have this transcript later on. Is it your testimony under oath that is it Dr. or York?
Mm-hmm.
Dr. York did an
York.
IQ test on your daughter Vivian in 2023 or thereafter?
It could have been 2022. She was in the 7th grade, I believe, at AJA when they were done. And the additional tester was Mr. Bryce Gibbs, your psychologist, I believe, and also Mr. Zeifman's psychologist. He also did IQ testing for Everett.
All right, I'll pass the witness.
Nothing further, Your Honor.
Okay. All right. You may put yourself back on mute. And Mr. Laverato, do you have another witness to call?
I do, Mr. Zeifman.
Oh no. Do we have more dramatic hamster coming up?
Okay. Mr. Zeifman, if you'll unmute, and I'll get you sworn in if you'd raise your right hand. Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, go ahead, counsel.
Thank you. Mr. Zeifman, I see that you've had your camera off, but I want to ask, have you been watching today's hearing?
I have.
Have you seen all the exhibits put up on the screen?
I have.
So all the different pieces of jewelry that I showed my client earlier, you saw those?
I believe so.
Okay. You're currently married to my client, and when were you married on this occasion?
Sorry?
All right, so this is the big dummy here, top right. Who probably is smart, but when it comes to dealing with women, big dummy.
Yeah, you've been married to my client twice. When did you marry her for the second time?
December 21st, 2022. Not the 22nd.
Okay, and the first time you married her was?
December 27th, 2021.
And you're claiming that there's a prenuptial agreement before each of those marriages, true?
Correct.
Okay. The prenuptial agreement related to marriage number one, did that include certain items of disclosure and financial health with regard to you that prenuptial agreement number two did not?
I believe that what was represented is correct, that there were some attachments to the first prenup. I don't recall precisely.
Okay, well, let me put something up on the screen to hopefully it'll refresh your recollection. Go ahead, Ms. Martinez, and put up petitioners one.
100 times. It's not, I didn't make this up.
Okay, thank you. Let me shift gears. I want to talk to you about the property that we're here for today. And that is, you saw rings 1, 2, and 3 and heard those discussed, correct?
I've heard what was.
That's all I want to know.
I've heard what was. I heard the testimony. Yes.
Okay. Do you
Excuse me,
remember
can
us?
we remove, excuse me, can we remove
Yeah,
exhibit
I'm
1?
sorry. Sure.
Thank you.
Thanks, Mr. Burnett.
I'm sorry, I didn't hear what Mr. Burnett said.
He just needed me to remove an exhibit. Mr. Zeifman, with regard to a wedding ring, did you ever give my client a wedding ring?
I have given her, I believe, 2.
Okay. And let's talk about the first time you gave her a wedding ring. When was that?
Okay. I'm sorry. I will also correct you that I believe that technically these would be referred to as, the first one would be an engagement ring.
Okay.
Okay. And the second one would be just a gift.
Okay. Well, let's talk about the first one then. And I think you just referred to it as the engagement ring. Did I show a picture of that earlier? Did you see that ring?
I wouldn't be able to say with any certainty whose ring that was, but it appeared to be an engagement ring. It's, it's a black and white grainy picture
Okay, so he was watching porn
from a distance.
Put up R1, Miss Martinez. Is that the engagement ring you were just talking about?
I believe so.
Okay. When did you buy that?
The latter part of 2021.
Where did you buy it?
I purchased it online.
From?
A vendor called Blue Nile.
Do you recall if this particular ring we're looking at is an Asher 5-carat diamond ring?
I do recall.
Is that what we're looking at?
It is not what you're looking at all.
Okay. Well, tell me about this ring then. How many carats is the ring that we're looking at?
I don't have the specs in front of me, but I believe that is a cushion cut, that the center stone is about 2.61 carats, and that is a Zach Posen setting from Blue Nile with a couple of smaller diamonds to the sides.
And I appreciate you describing that. I had no idea what you said there or understood it, but let me ask you this. What did this ring cost?
I recall it costing somewhere between $25,000, $26,000, and $30,000. I don't know precisely.
Do you have any documentation to that effect?
I'm sure that I can obtain documentation.
Okay, because we've asked for it and I haven't received it. So if you can secure that for me, I'd appreciate it. Now, you talked about another ring that you gave her. You corrected me. I think I called it a wedding ring, but you said you would refer to it as a gift. So we've just now talked about the engagement ring. Take that down, Ms. Martinez. Tell me about the gift ring. What was that?
Fairly in the recent past, a almost 10 carat mine cut diamond ring in a platinum setting was obtained at Audrey's request.
When was that?
I don't, maybe 2024, something like that, more recently.
How much was that ring?
I don't recall exactly. It might have been in the neighborhood of, $10,000 plus or minus, maybe a little bit more. I don't recall. They're not that expensive.
I guess that's relative, but let me ask you this, as far as ring number one, the engagement ring is concerned, where is that ring right now?
I do not know, sir.
When was the last time you saw it?
I don't recall. I just don't recall. I don't know.
Well, did you have it in your possession the last time you knew where it was?
I did not.
Who did, as far as you know?
Audrey,
You didn't take that ring to secure it or clean it or do anything with it.
I did not.
What about the gift ring you just talked about? Is that with you?
It is not.
Where is that, if you know?
I don't know, but I believe that Audrey testified that it's with her.
Not sure what you heard, but she's certainly wanting you to give back what she says are 3 rings, but you don't agree that there's 3 rings at all, do you?
I do not recall this this third ring that that is being discussed.
Other than the 2 rings you just described, sir, are there any other rings that you gave my client?
I believe that there were numerous gifts along the way, what would be called a wedding band, and other, what do you call it? Just
Okay, this still isn't making sense for me. Like, I understand where she's trying to get stuff, but unless she's made some huge claims, these rings, this is small potato stuff for this guy. Whatever he makes, if he's in the $100 million plus range, this is chump change. I don't know why you wouldn't get rid of her and get your piece back. Unless she's asking for, $100 million or something like that. I don't know why we're discussing this.
run-of-the-mill jewelry.
What is run-of-the-mill jewelry? I don't know. You tell me.
Just a ring, not an engagement ring. That's like not a diamond solitaire engagement ring.
Where is that jewelry, sir?
I don't know, sir. As I've told you before, I don't know.
Do you recall?
That's interesting. I have no idea, but I don't have the sensation of any emotion from her whatsoever. None. But I could be misreading it.
Me showing a picture to my client that was of a silver container, a box, if you will, that had jewelry within it?
I believe that I heard her refer to an anthropology box.
Yeah.
Which...
Miss Martinez, bring that exhibit up, please. Do you recall this box, sir?
I may have seen the box along the way in her possession, but I don't know the box, and I would never have guessed it was from anthropology either.
That struck you, that she said it was from anthropology?
Yeah, I haven't shopped at anthropology. I haven't been in the store in many, many years.
So she said you had it last, that you took possession of it in the kitchen over at the compound. You remember, recall that testimony?
I do recall that being said.
And you're saying that's not true?
I am saying that's not true.
Ugh, anthropology just sucks. And there's nothing really wrong with anthropology per se, but just hearing that hearing that fills my heart with joy. Thinking about the stupid shit that I no longer have to do, like walk through anthropology.
You can take that. Well, before I do that, do you see that gold bracelet towards the front of that container in this photo?
I see what appears to be a gold bracelet of some sort on the left-hand side toward the front. Yes.
Okay. Do you recognize it?
I do not.
You
You
have
see
10
those-
minutes, 10 minutes
Oh
remaining.
boy. Okay.
I don't believe I've ever seen Audrey wearing that. I don't recall that item.
Mr. Zeifman, you don't have any jewelry of hers in your possession?
I do not.
Take that photo down, please, Ms. Martinez. Do you have the passports?
I do not.
Who has the passports, if you know?
I do not know. I've told you I do not know. I did not control her passport or her children's passport ever.
Mr. Zeifman, you haven't paid any attorney fees yet, have you? Not a dime.
I don't. I don't believe that I'm paying attorney's fees.
Why not?
I mean, that's my arrangement with my attorney.
Well, your attorney's representing you in this case. It's contested. There's been 2 depositions.
That's his arrangement. Maybe he throws them millions of dollars in other business a year and they just have to deal with it. Who cares?
There's a ton of documents. And how is it that there's an arrangement that you have a lawyer doing all that work for nothing?
I didn't say, we have not discussed how this will get compensated. I have a well-established relationship with Michael, and
they aren't doing it for free. He's taking care of them. The specifics of it don't matter.
We'll figure it out.
I'm not sure what that means, sir. Can you
Well, sucks to be a brokey, doesn't it?
explain that?
I'm not sure
Yeah,
the relevance of this, Your Honor. I'm going to check to the relevancy. My fee arrangement has nothing to do with his client's fee arrangement with him.
What's the response, Mr. Lorado?
Well, Judge, I have a client that has a bill that she gets invoiced every month, like most lawyers I know, and she can't afford to pay it. This particular person who's got tons of resources hasn't paid a dime, and I want the court to understand what that's all about, especially when I'm.
Now you're gonna cry. Where?
I absolutely hate that argument. Absolutely hate it. You just make yourself look awful and petty. It's none of your damn business. The man conducts a lot of business. Law firms know how to take care of themselves. They're not doing this, but out of the goodness of their hearts. They're being compensated in one way or another, and it doesn't appear to be illegal. Unless you have information to that effect, shut up.
I'm asking him to pay for my fees.
Same objection. The law is clear that my fees, my invoices have no bearing on whether his client should pay him.
I'll sustain the objection.
Mr. Zeifman, you're under oath. You understand that?
Yes,
Have you told the court the truth today?
I have.
Have you ever forged a document to the IRS?
Have I forged? Are you referring to my having a dog sign an appraisal for a donated property?
Yeah.
Yes, I
I'm
told
referring to
everyone I told everyone who would listen that funny story, and I told the IRS what I did.
So under oath at your deposition, you swore that you purposefully signed your dog Solomon's name as an appraiser that you sent over to the IRS?
More
Oh,
precisely,
God.
I donated a property and I deducted the amount of money that the property was sold for at closing. And at the last moment,
Oh my God, this attorney is just be clowning himself in the worst way. There's nothing there. There'd be charges and we'd be hearing that. This guy isn't doing anything funky. You're just sad because he has more money than you. It's pathetic. Stop it. You're embarrassing yourself.
my accountants asked me for an appraisal, and I provided an appraisal signed by Solomon King, and I told them that Solomon King was my dog.
you told the IRS that Solomon King was your dog?
I did. I told my accountants, and because I had deducted precisely what the property was sold for at closing.
There was a sale. He used that. It was a bit of a joke. This is not, you don't have a smoking gun here. You just made a jerk of yourself.
Never owned by the nonprofit for more than a millisecond.
To be clear, that Solomon King that you're referring to is the same Solomon King that you signed that dog had medical records where you got some treatment in Hawaii because you didn't want the doctor to know who was actually getting the treatment, right?
I self-paid for a biopsy and wanted it done anonymously. So I used Solomon King's name.
And you thought that both of those things were truthful, right?
There's nothing. Again, I don't know. These are the incidents. He uses another name because he doesn't want to know about treatment. That could have major business implications. Everything. He's not breaking any law. He's not doing anything wrong. This guy's like chasing him around for money, pumping up a bill for $130,000. He hasn't done $130,000 worth of work. Let's audit that bill. He said that he's billed $130,000. Why? Because Mr. Zelfman has money. And he has the unmitigated gall to then sit there and try to make him look bad. Now, I don't know this guy, and I'm not defending him, and I don't represent him. Maybe he's done a bunch of sleazy crap. I doubt it. I don't think so based on what I'm seeing here. But maybe he has. But this isn't it. You didn't catch him, even if he did. Oh, my God.
Sorry?
No further questions, Judge. I'll pass.
Okay.
Mr. Zeifman, did you ever ask or instruct Ms. Zeifman to have her children IQs tested?
I certainly did not.
And you heard her testify that earlier this afternoon, correct?
Yes.
Was her testimony a complete fabrication?
Complete fabrication.
Okay. Since you married Ms. Zeifman for the second time on December the 21st, 2022, did you and her ever cohabitate together?
We have not. She's at all times had at least one separate residence that I did not access.
Okay. And who paid for those separate residences for Ms. Zeifman?
I did.
Okay. Why did you not allow her to live with you and your children in your home in Austin?
Because of the experiences, the first marriage, and that precipitated the first divorce.
Yeah, I think
Okay, that's weird. It's smart. He's smarter than I thought. That's good that he didn't trust her. But why did you remarry somebody that you would not trust to be in your home? That is a strange move. Maybe we'll find out.
you're pretty clear you're not in possession of any of Ms. Zeifman's alleged jewelry in this, the subject of this hearing. Is that correct?
I am not.
Was March of 2026 the first time you were notified of her claim that you have her jewelry?
Yes.
When you filed for divorce last September, where did Ms. Zeitman live?
She lived at Bunnell Court,
And-
in a residence that I had provided for her exclusive use.
Right,
And
did that
she
re-
had exclusive use of the Sweetwater property and a house in Midland. as
Did
well.
you ever access her property on Bunnell Drive?
I did not. I did not even. I waited for your say so to even have people go and clean it up
Okay.
after she
And then
moved out.
and at the time she moved out, did Ms. Zeitman make a claim that she had suffered personal injuries at that place due to mold?
Something to that effect.
And did she say she had to move out of there because she had mold-related injuries?
Something like that. I did not really get into the. I found I found the claim quite offensive and preposterous.
Okay, why did you find that claim offensive and preposterous?
Well, it followed the filing for divorce. And this was the property that she wanted to live in and had control of, and all I did was pay. So, I just,
Why did you file for divorce?
well, in the fall of 2025, after returning from the summer,
Well, that was Zach. Going in, I said, this thing is long and it's live. Can you back this up for me? And he said, yes. Actually, I didn't. KDM did for me. And I'll be damned if you didn't get it done.
Audrey was spending a lot of time. She was visiting her son some of the time and leaving Vivian with me. And she became involved with her mom in a way that was completely violative of our agreement.
Clifford, buddy, you're doing this all wrong. Oh my God. I feel like I should take him out and show him how it's done right. Like a public service. I think I will. That would be fantastic. That is a pro bono work for a billionaire. I love it. That'll irritate the pearl clutchers.
What
do you mean by that?
Her mom was at what's it called, a memory care facility at a assisted living place, and I had put money up for that, and I had assisted with smoothing over misunderstandings with the state of North Carolina and the county of, I think it's Gillespie County, and I had agreed to be like a financial caretaker for the mom who was experiencing.
Hell no. We'll pay our own expenses. I don't want a dime. I just for the good of humanity, I'm going to show this guy how to enjoy life.
Dementia. And this turned into another attempt by Audrey to gain control of the mom's person and estate in complete contravention of everything that was agreed.
Okay. Do you have personal knowledge of Ms. Zeitman forging a document to get her mother into Westminster?
Oh no. Are you serious? Did this happen? I need to see it.
Yes, I saw that, and
are you aware
yes.
Are you aware of Ms. Zeifman trying to take control of her mother's money?
Yes, the close friend of her mom's, the childhood friend who had helped the mom, relocate from. I had assured everyone that this was not the same Audrey. This was not going to happen again, and it did happen again. I'm aware from that lady that Audrey has threatened her, told her she doesn't want her to see the mom. Everything was.
Sorry, I'm muted. Objection, hearsay.
That's fine. We'll move it along. I'm short on time. Mr. Zeifman, was Audrey Zeifman previously married to a person named Kip Lewis?
I believe so.
Okay. And did Audrey admit to you last year that she falsely made a claim that Kip Lewis sexually assaulted one of her daughters?
Yes, she did, but she said that he was a creep, so it didn't matter.
And isn't it true that Kip Lewis was arrested here in Austin for sexual assault of a child, correct?
I don't know precisely why he was arrested, but I do know that he was arrested and that all charges were dropped by the DA, by CPS, and by APD. And I understand that that is not a typical outcome.
All right. Now, when you executed the second prenup on December the 21st, 2022, was Ms. Zeifman on a walker as she testified before Judge Mangrum this morning?
Not at all.
Seriously, I feel bad for this guy. He's wealthy and that's great, but he doesn't. I know this personality. I know a lot of guys like him. I know what's holding him back. Generally, his life is quite good, but I know the thought process and why he's not functioning well in this context. And I know how to deal with it. He's not a bad guy. I can tell.
Was she on crutches?
She was not.
Was she using a cane?
I do not believe so.
Did she have a trip planned to go to Cozumel with some friends 3 days earlier on December the 18th of 2022?
Basically that.
Yes, what was told to me was that she had a trip with some friends because she needed to relax, but it turned out that it was a trip with her, the boyfriend that she had in the summer of 2022, and that I believe she has since reconnected with at various times during our marriages.
Okay, were you at Ms. Zeifman's deposition?
No, I was not.
Okay, and do you know the name of the so-called entity or employer where she testifies she just got a job making six figures?
I do not.
All right, did you ever contact any employer of Ms. Zeifman's?
I did not. I'm not aware of any employer of hers.
Now, Ms. Zeifman testified that she took a trip with you to Portland in early 2023, and during that trip, you took from her that first engagement agreement. Do you remember her testimony on that?
I believe so, but I believe that that is all erroneous.
Okay, when I said engagement agreement, I meant engagement ring. Do you remember her testifying that? Okay,
I believe so.
Okay, did you ever take from Ms. Zeifman that first engagement ring? Did you ever take possession of it away from her?
I did not. I believe that I visited Portland with her one time in December of 2021 to obtain the engagement ring that I was shown the picture of, which is that Zach Posen setting with the two side diamonds. And that's because Oregon.
The wonderful days in Portland. The ugly engagement ring and the starfish special. I remember like it was yesterday.
Has an advantageous sales tax rate of 0%.
And of course, that would have been before you got divorced the first time, correct?
That is correct.
In fact, it would have been before you got married the first time, correct?
Correct. It was an engagement ring, and
Now, do you recall Ms. Zeidman's testimony this morning saying that she wanted to use the Sweetwater residence after you filed for divorce and she was going to get her belongings and you said no? Do you remember that testimony?
yes, yes.
All right. What was all that about? And did that happen after you filed for divorce?
No, that was not about using the suite. It was when her grandmother was near to dying, that the caretaker, who had already packed up her property, her personal belongings at the residence that I own, and that she previously said she owned in the other divorce, but I've owned it for quite a while. The caretaker called and said that Audrey and her father had each called and said that I had, given her permission to stay at the house. And I communicated through the caretaker, and I'm certain I communicated to you that Audrey's property would be made available for her at any time, but that she was not welcome on any of the premises that I own. And I'm sure that contemporaneously I had discussion with her father's sister, her aunt, telling them that if they wanted to go on the other property that I own in Sweetwater, which is near to the graveyard, the cemetery, that they would certainly be that they could use my premises.
Okay. Have you ever refused to give Ms. Zeifman back any belongings that are in your possession, custody, or control?
No.
In fact,
and going
you
back
want her
to
to get the stuff that you have.
Yes. And going back to the funeral, I had a cordial relationship with her aunt and with her grandmother. And I appreciated that her grandmother maintained a supportive relationship with the state of Israel, and I made a contribution after she passed away, and I may or may not have shared that with you. I shared it with the aunt.
Okay. Now, while this case has been pending, under the prenup, do you have any obligation to provide any support to Ms. Zeifman?
I don't believe that I have any obligation. I continue to be paying for a life insurance policy that it's billed monthly to my credit card. She continues to collect a small salary, which provides for her health insurance and whatever other benefits she signed up for through my company. And I believe that her phone and her daughter Vivian and Everett's phone and her son Everett's phones continue to be on my T-Mobile plan. And the other thing is that Audrey has many times accused people of invading her electronic records and stuff. And
Objection,
so
non-responsive, Judge.
the email addresses that I maintain, the email domains, I have not touched at all, because I don't want to.
Okay, I got to hurry.
Objection, non-responsive.
I'll sustain that.
Okay, lastly, Mr. Zeifman, look at petitioner's exhibit number 6. Council asked if you had any records showing what you paid for that first ring. Now, if you go down to the third page,
It's going to be close to what I told you, 26,000. I can't read. It's too small.
okay,
What
is
does it
this the
say?
ring? Is this the ring that it was the first engagement ring?
Yes, the Zach Posen ring, and it's about $26,000. Correct.
And if you go to the first page, the email from Blue Nile, you see the date, November 23rd, 2021.
Yes, yes, and we went to Portland in December of 2021, as I indicated.
Offer petitioner's exhibit number 6.
No objection.
It's admitted.
All right, I passed the witness.
Mr. Zeifman, briefly, you mentioned that my client made up a story about Kip Lewis, a very serious story that resulted in his arrest. Is that your testimony?
I don't know if she made up the story from whole cloth. I do know that over the years, she's acknowledged that that she made allegations and stood by allegations that were incorrect. She apologized to his sons for what
She is pure scum, in my humble opinion.
she did.
Okay, so I want to be very clear about this because it's a very serious claim you're making here. Did my client tell you that she made up a story about Kip Lewis and some sexual misconduct that resulted in her arrest? And that even though it wasn't
No,
true, hold on, let me finish,
I don't
sir.
believe she was
Sir,
arrested.
I need to be able to finish my question.
You just said she was arrested.
Let me ask it again.
Yes.
Did my client tell you that she made up a story about Kip Lewis and some sexual misconduct that he perpetrated that resulted in his arrest, and that even though it wasn't true, it's okay because he's a creep, or words to that effect?
She did not. She said that her appearance in a documentary film, saying that she saw videos and all of the things she said to corroborate this, she acknowledged were embellished and untrue. Margaret Moore went on TV and said that Audrey.
Did you tell the police or law enforcement or anything like that, or
The
anybody
police.
like that? Sir, I need to be able to ask my question. When you learned from my client that she embellished, as you said, regarding another person, specifically related to Kip Lewis, did you go and report that to anybody?
I did not. My understanding was that it was fairly well accepted that all charges against the man were dropped.
Is there anywhere in writing, sir, where you have some communication from my client where she's admitting that she embellished anything about Kip Lewis?
No, I'm certain that I saw text messages apologizing to his sons for perpetuating things that she did not know to be true.
You're saying that you've seen text messages from my client to Kip Lewis's sons saying that she embellished about some misconduct of Kip Lewis?
100%. I believe it's Cooper and something else. Cooper and I don't remember the names.
This guy's telling the truth.
But I was married to her at the time.
Matter of fact, you helped her out prior to being.
I have no idea why he ever married her. And I'm even more astonished that he married her a second time. While still wise enough to not let her into the house because she's not trustworthy, which she's not. But why the hell did you marry her?
Being married with regard to the whole issue surrounding Kip Lewis, didn't you? You helped her get legal assistance, correct?
That would be completely incorrect. When I met Audrey, she claimed to be in this morass with Kip Lewis and with her mother, only she was the pursuer. She wasn't. The advice was to leave everyone alone.
I'll pass the witness, Judge.
Suck it. And then I would ask anything else. I would ask anything else if I was an attorney. I wouldn't end my examination on that absolute whipping I just took. I wouldn't do it.
Else?
No, Your Honor.
Okay. I take it there are no more witnesses to be called today.
There are not, other than myself. I was just going to submit my attorney fees on the attorney fee affidavit, if that's okay with everybody.
I am going to object to the hearsay on the affidavit. I further object to the billing invoices attached to the affidavit. Your Honor, they're so heavily redacted, it's impossible for me to testify, to be able to ascertain what they've done or not done on this case on the billing records. And there, if you take, for example, they'll just say redacted prep 1.5 hours throughout the whole bills. It's like this. It's impossible. There's no way I could ever tell under the case law that is insufficient to support attorney's fees. I'm supposed to be able to ascertain from the invoices what the work has been performed. And the reason why it's particularly important in this case is because based on the affidavit that they've typed up and want to introduce into evidence, they billed almost $48,000 in connection with this motion dealing with the jewelry alone, which I think is excessive. That exceeds the total amount I would have billed Mr. Zeifman and going to bill him for the work on everything in the case, including depositions, exchange, and discovery. And so I object to that testimony.
Okay. What's the response?
Well, first of all, Judge, his client testified he hadn't paid a dime. So there haven't been any attorney fees as it relates to Mr. Zeifman. But I have an unredacted copy if Mr. Burnett would like a copy.
So what? How is that relevant to this? We're talking about you and your bill.
Of that, that's fine. On the other hand, if you took a look at what they redacted in the prenuptial agreement and the disclosures attached to that, which I really wanted to discuss with Mr. Zeifman, all of that was redacted as well. I figured since we're officers of the court that the affidavit and the numbers that I've discussed in that affidavit would suffice for Mr. Burnett, but I have an unredacted copy if you'd like to share, if you'd like to see that.
The problem I have, Your Honor, is that I've not been provided a copy of the unredacted billing invoices prior to today. And so I don't have an opportunity to go through them. I don't question counsel's representation that he's billed that amount. I'm almost positive it's true. Okay. That's not my dispute. My objection is based on I have no basis to go through those invoices and question or cross-examine counsel about the reasonableness of those bills and those invoices and those charges. Because you can only recover, if you're allowed to recover attorney's fees, which I don't think you can based on the Eaton case, but if you were allowed to recover them, you can only recover reasonable attorney's fees under the Texas Family Code. And it's impossible for me to cross-examine him or to show the court that $48,000 is an unreasonable amount to bill somebody for the motion that we've been here today that involving a 3-hour hearing.
Okay. I understand both of your positions. I will overrule the objection. I'll admit what exhibit is the affidavit.
Judge, the affidavit is exhibit R819 in the box.
R19.
Yes,
Okay.
ma'am.
And so as far as the unredacted invoices, are you wanting to offer those in addition to the?
I'm happy to do that, Judge. And I
Okay.
can send a copy to Mr. Burnett too, right now.
Okay. And I think practically speaking, Mr. Burnett, there's not going to be the opportunity to cross-examine because frankly, y'all are both out of time on this. But I understand the arguments and I'm going to take the time to read through the Eaton case and the briefing that you provided.
Thank you, Your Honor.
Okay. If y'all would like to do, well, let me see. What court admin is sending us another case, but I am going to go ahead and allow you just to do a brief summation of the evidence and what you're asking me to do or not do. But I'd appreciate it if you would, keep it brief because they are sending me another hearing. That's the folks are supposed to show up around 2:30. So go ahead.
Judge, if I may, if I was talking to a jury, I'd do some sort of summary because you get it. And so you've heard enough of me probably. I'm just going to tell you that this is a case where there is a major disparity between the have and the have-nots. You have Mr. Zeifman here that hasn't paid a dime, which is so telling to his attorney, because they have this special relationship or friendship. And
I can't believe an adult lets these words come out of their mouth. It's so embarrassing. This has no place in the law, and it's all over. People think that this is an okay thing. He's got money, so we should just take it from him, and he's a bad person as a result of it. It's insanity. Straight commie bullshit. But carry on, counsel.
I'm not going to fault Mr. Burnett for that. People can have friends. But on the other hand, you look at my client, who is essentially a single mom with 2 minor kids. She's cleaning houses, and he didn't provide you any evidence.
Cleaning house. She testified she cleaned a house. It was a complete lie, and we all know it. And you probably put the stupid idea in her head. But literally, her testimony is that she cleaned one house and didn't get paid for it.
Refuted that. And she's asking for some help, because if you look at Eaton, the Eaton case, Judge, deals with a postmarital agreement where the parties agreed what the community was and was not. The issue of whether or not the postnup was valid or not, that wasn't Eaton. This case is exactly whether or not the prenuptial agreement is enforceable or not. And so in order to be able to bring...
It is. This is standard argument. Of course it's insane. And it's a standard political argument now too. I mean, I think people should be tased for suggesting these things. Honestly, immediately tase them. Somebody else has more. Therefore, I'm entitled to it. No, somebody else worked for it. Give us a legal basis for why they owe you money. Anything else, I'm not listening to.
Bring those claims and actually meaningfully participate in this litigation, which I'm told if they lose, it's going all the way up to the Supreme Court. She needs some help from you, Judge. And for someone to get up here and say that they don't know where any of this jewelry is, even though it's clear that it existed, and then just...
I doubt he knows where the jewelry is. I really doubt it. I purchased some jewelry during during the course of my marriage. I have no idea where the hell it is or whatever happened to it, and I don't care. No heterosexual man gives a shit about jewelry.
Take the stance of, well, I don't know, so you're out of luck, especially when he's got the resources that he does, that at a minimum, Judge, if you're not going to order him to pay for some fair market value of that, then I'd ask that he definitely be ordered to pay for interim attorney fees so that this lady can have an opportunity to meaningfully proceed in this case.
Turn in your man card, you lose.
I submit it.
Okay. All right, Mr. Burnett.
Yes, Your Honor. The requested relief dealing with the property in dispute is premature. And it's like he denies having it. If they dispute it, they can sue him for conversion. We can have a full trial where the jury can decide the credibility of the witnesses. Other people can be brought in. And then if the jury or court finds that he does have possession, then they can determine what the fair market value of it is, and he may owe her damages. Okay. But that's not a temporary orders issue. That is a final trial issue. And that's number one. Number two, there's zero legal authority for them to recover attorney's fees in support of their motion for temporary orders on the property dispute. Third, dealing with their motion for interim fees. The Eaton case is right on point. And there's no difference in the family code between a premarital agreement and a postmarital agreement. In the Eaton case, and you and your briefing attorney will see, is that in that case, there was a post-marital agreement that the court, is black letter law, is
prenup is better than nothing, but it's not very good. You hear this crap, and these things, they just make this up, and you're literally just rolling the dice with whatever goofy judge you get in front of. That's the truth. There's no basis for it in law, what they're asking, but if they've got an agreement, they can make an argument.
Is presumptively valid, has to be honored by the court until there's a final order setting it aside. And in that case, there was a post-marital agreement that provided, and I'm going to quote, for no community estate. It wasn't a case where they said what's going to be community and what's going to be separate. It said no community estate in the Eaton case. Just like in the case we have here, the first prenup, and really the only one that's relevant today is the second prenup. There's no community estate. It's the exact same thing. And in that case, they had waived and released any claim against each other's separate estate. And that's exactly what they've done in this prenup. Is Ms. Zeifman waived, released any claims acquired or acquired in the future against his separate estate. And in the Eaton case, the trial court nonetheless ordered interim attorney. It was a temporary orders case. It's the only temporary orders case out there. The only one out there. And in that Eaton case, the trial court ordered interim attorney's fees that, based on the post-marital agreement, could only come from his separate estate. And they appealed it on mandamus, and the Court of Appeals reversed it. It said it was abuse of discretion to order him to pay attorney's fees from his separate estate on temporary orders basis when the spouse had released and waived any claim against that separate estate. I mean, you couldn't have a case more on point. The only difference between the two cases is, in the present case, we're dealing with a prenup, and in the Eaton case, it dealt with a postnup. But again, finally, under the family code, that is no distinction with any meaning at all. You can do it before you get married, or you can do it after you get married. And if we'd have a separate argument after we have this bifurcated trial. We go to trial first if they're able.
Postnup. I think we would be in a better place if he made his decisions after he had some post-nut clarity. I think that's where the problem is here.
Able to set aside the second prenup, then there's a presumption that everything is community. At that point, they can come in and ask for interim fees, but they can't do it now under the case law. And I would respectfully request that if the court does allow or order any interim attorney's fees, that you include in your order, Your Honor, with all due respect, that such amount be deposited into the registry of the court. Because if he has to pay her directly, the money's going to be gone. And if there's a appellate relief, we'll have no way of getting the money back. That's all I have. Thank you, Your Honor.
Your Honor, can I just make one suggestion maybe? And that is, if the court wants, maybe we can do a reply brief to what they've just submitted. They just submitted this to me this morning, this Eaton case, and my read of it's much different than his. So if the court would like that, I'm just offering it.
So I don't know that I'm going to need that.
Okay.
I'm going to pull the case and read it and see what I think it means. So I don't want to cause you to spend more time and energy on something that I'm pretty sure I'm going to look at and get out before the holiday weekend.
Sure.
So that's my goal. So I'll decline that invitation, but
Okay.
I do appreciate it though. I'm going to look at everything. I'll take this under advisement. My goal is to, let's see, Friday's a holiday. So my goal is to let you know by the end of business tomorrow what my thoughts are on this. Any questions?
No, Your Honor. Thank you very much.
No, Your Honor.
Okay.
Thank you, Your Honor.
Thank you for your patience and letting us take care of those short hearings first. And seeing nothing else, y'all are all excused from the virtual courtroom. We do have our other litigants waiting, so we'll let you go before we bring them in. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Take care. Happy 4th.
Happy 4th.
Here.
Ah, well, there you have it. There you have it. Here's the situation. You guys probably don't want to hear this, but I'm going to tell it to you anyway. And this is why I feel sorry for this guy. I've never seen him before. I've never seen her before. I didn't know about this until this afternoon. Katie shot me a message. It was interesting. Although now I have to go back and edit the gap out, but that's okay. And thanks again, Zach, for saving me. But here's what I see. She is straight gaming him. I think we can all see that. She's just a straightforward gold digger here. That's understandable. He makes a lot of money. She doesn't have any discernible skills or any sense or any personality. So she's got to cash in one way or another to eat. It's not nice, but it's rational. I understand what she's doing. I don't understand, but I do have a theory, and I'm going to give it to you now. This is a nice guy. I shouldn't say that. I don't know where he is, but here's the vibe I get from him. He's been very successful in life. His guiding principle in life is to make his mother happy. He's got old, traditional Jewish family values. He wants to do things right. He wants to make his mom happy. That's what drives this man. And he views this marriage, it's not that he's so into her. He knows that she can't be trusted. He knows that she's a liar. He knows all these things. But he has internalized this. And he thinks the fact that this marriage didn't work is a failure on my part. And it's a disgrace. And I need to rectify it. It's not an emotional attachment to her. It's that he feels that he failed. He's wrong. Well, he failed in that he got married to her and she's awful. But you can't, without a time machine, you can't fix that. So out of guilt and a sense of responsibility, he tries against all logic to fix it. And it's impossible. And that's why I feel bad for him. That's why I have an overwhelming urge to take him out and show him how to live life. Because obviously he does a lot of things very well and is quite successful. But he's got some issues in this area. And it's just kind of sad to see a guy with that much together go down in flames over this nonsense. That's how these guys get tripped up. They can't conceive of somebody being as shallow as this woman is. It's not in their brain. It short circuits. They think, oh, surely there's some good in there that I could bring out. No, there isn't. No, there isn't, my man. I could be wrong, but that's the way I see it. That's just, I'm no therapist. I don't claim to be, but I've lived a long time and I see how the world works, and that's what I see.
Damn, you may kiss your bride.